I'm Jim Moran, Los Angeles. Los Angeles Police Detective Mark Furman will try to weather more intense questioning by O.J. Simpson defense attorney F. Lee Baily today. Defense attorneys contend that Furman is a racist who planted evidence he says he found in O.J. Simpson's property in an attempt to frame Simpson. For more on the trial, we go now to CNN's Greg Lamont, who is outside the courthouse. Greg?
There's no telling how long Detective Mark Furman will actually be on the witness stand, but one thing's for sure, when he retakes the stand today, he can expect more blistering questions from defense attorney F. Lee Baily. And if Baily picks up where he left off yesterday, we will undoubtedly hear more about alleged racist statements that Furman made to a woman named Kathleen Bell. Baily played the race card yesterday by asking Furman if he ever used the N-word in the presence of Bell and if he ever suggested violence against African Americans. He replied no to both of those questions. Baily seems to be going back and forth from the issue of alleged racism to the planting of evidence. Baily suggested that a bloody glove was picked up at 875 South Bundy, the scene of the killings, and then put in plastic or some sort of rubber and then transported to O.J. Simpson's estate on Rockingham. Furman said that did not happen. Today, we would also expect to see the prosecution raise a question about a statement made yesterday in the courtroom by F. Lee Baily. Baily said that a Sergeant Max Cordoba was allegedly called a racial slur by Mark Furman, and he said that he had talked with Cordoba about that issue on the telephone. But Cordoba is saying that he has never spoken with Baily, and today Furman's attorney talked about that issue.
I'm waiting to see what the judge says about that this morning. I want to see what Mr. Baily says about it. Mr. Baily stood up in court and he said very clearly that he spoke to Sergeant Cordoba. Sergeant Cordoba said, I never spoke to Mr. Baily.
How's Sergeant Furman holding up?
I think Sergeant Furman, Detective Furman, Detective Furman is doing great.
Baily entered the courtroom just a few minutes ago, and here's what he had to say about the Cordoba issue.
No, he didn't say that at all. He was confused. We've talked to him. We're calling Dateline so they can correct it. He did speak to me.
Furman's attorney now says the issue in the courtroom is F. Lee Baily's credibility. On another issue, the defense has been ordered to hand over all notes, paperwork, and reports regarding defense expert witnesses. The court order orders the defense to hand over those items to the prosecution by no later than the close of business today. Otherwise, the court will impose sanctions on the defense. In the judge's order, the order seemed to suggest that without a court order, the defense might continue to hide evidence from the prosecution. Jim?
Thank you, Greg. In what could be a crucial test of credibility, Detective Furman will likely face more questions about racist comments he allegedly made to former U.S. Marine Max Cordoba, as Greg just mentioned. The incident allegedly occurred at the same Redondo Beach, California Marine Corps recruiting station where Kathleen Bell claims Furman made racist comments to her. Defense attorney F. Lee Baily introduced the allegation regarding Cordoba yesterday while the jurors were out of the courtroom.
Max Cordoba is a black Marine, African American. As I indicated in the proffer, Max Cordoba was standing in the recruiting station when Detective Furman came up with some papers. There will be evidence that Detective Furman was making application to join a reserve unit and that the Marines, or some of them, were concerned about where in the world they could put him that he wouldn't have to associate with African Americans, because he'd made his feelings plain about that. Now, as Cordoba is standing there, and Furman approaches with the papers, Cordoba says, I really don't know anything about this application. You ought to see Ron, meaning Sergeant Ronald Rohr. At about that moment, Rohr, who likes to hang around at the place next door, as another witness will testify, starts coming across the street, and Cordoba says, hey, Rohr, your boy is here. And Furman turns on Cordoba and says, let's get something straight. The only boy here is you, nigger. And then Cordoba leaves the building, and Furman follows him out into the parking lot and repeats the same epithet.
Cordoba failed to remember the incident when questioned by Los Angeles TV station KCAL last September.
Did Mark Furman ever make any racist comments?
Not in front of me, no.
Speaking again outside the presence of the jury yesterday, defense attorney Baily indicated Cordoba would back up the defense team's version of the events.
Your Honor, I have spoken with him on the phone personally, Marine to Marine. I haven't the slightest doubt that he'll march up to that witness stand and tell the world what Furman called him on no provocation whatsoever.
However, in an interview that aired last night on the NBC program Dateline, Cordoba again appeared to contradict Baily.
No, I have not talked to F.Lee Baily.
Defense attorneys must wait for prosecutors to interview Cordoba before they question Furman about the ex-Marine in court. Throughout most of the cross-examination on Tuesday, Furman remained unflustered. So at one point, Baily began questioning him about how the prosecution prepared him for the ordeal.
Now, when you were examined by the three lawyers you have named, what was the nature of their question?
Cross-examination.
These were leading questions and suggestive questions.
I don't think I know what you mean by that, sir.
A leading question is a question that suggests the answer. For instance, you are Mark Furman, not what is your name. You understand
No.
the difference?
I understand the difference, but no, they weren't.
Were any of the questions abusive?
I don't know if I...
Insulting?
No.
Nasty?
No.
What were you told was the purpose of this exercise?
To prepare me for cross-examination.
Okay. And what were you to guard against in cross-examination that this preparation would facilitate?
I don't think I was told...
Sustained.
Were the questions that were being put to you as simulated cross-examination, in your mind, an attempt to assist in preparing you to withstand a real cross-examination?
No. I think they're areas and questions that have probably never been asked most detectives or policemen.
Can you give me an example?
No, I can't.
Can you think of any language that was used in those questions that some might find offensive, Detective Furman?
No.
None?
No.
Can you remember even one of the questions that these three lawyers put to you?
No, I do not, sir.
Not a single one?
No.
May we then assume that you did not profit by the experience of preparation for cross-examination?
I don't think it was very productive, no.
For some thoughts, let's go now to our legal analysts. Greta Van Susteren is a trial attorney and adjunct professor at Georgetown Law Center. She joins us from our Washington studios. And Stanley Goldman is a professor of law at Loyola Law School here in Los Angeles. Welcome to both of you. Professor Goldman, first to you. What do you make of this apparent inconsistency between Max Cordoba's statement that he never spoke with F. Lee Baily and F. Lee Baily's statement in court on the record that he did, in fact, have a conversation Marine to Marine? Do you think this will ever come out in court, and how important is it?
Well, I've got to believe in a normal case that a man like F. Lee Baily is not going to go into court and say a thing like that before the judge and the world without having a basis for it. I only hope that, in fact, if that conversation did take place, there was some third-party witness to it, an investigator, another attorney on the case, a clerk, because if Mr. Cordoba denies it, whether it took place or not, it's going to make F. Lee Baily look very bad, and one wonders whether he'll even be allowed to use any of this information ever in cross-examination when the witness says, I didn't say that, and I won't testify to that.
Greta Van Susteren, do you think that the prosecution will mount a challenge to the use of this witness in court?
I think what the prosecution is going to try to do, first of all, is bring the issue before Judge Ito this morning, because it's a very serious allegation to make against a lawyer that a lawyer has lied. If F. Lee Baily has lied, this is going to create a serious problem in this case, and Judge Ito is not going to be happy and could take such steps as to hold a contempt proceedings. If, on the other hand, F. Lee Baily didn't lie and that Mr. Cordoba is either confused or is lying himself, then I think we're just going to proceed as normal. But I don't think the defense will be calling him as a witness, because he certainly doesn't look like he wants to help the defense at this point.
Stan, it's clear that yesterday the defense played the race card in questioning with Mark Furman. Where does the defense go from here, and how does the prosecution respond?
Well, I think it has played the race card. Whether it could play it much longer is an interesting question. It may not have totally exhausted it, but it's getting close to the end of what it can do with respect to the evidence it's got. If it can't use any of the other racist evidence, alleged racist remarks made by Mark Furman, it's going to have to stop pretty soon. The prosecution's just going to have to go back through it and say, again, you didn't say any of this, you didn't say this, you didn't say this, you don't remember meeting this person, would you have said this? Would this have made sense? She'll probably get objected to a few times by the defense when she asks them, would it have made sense for you to have said this kind of questions? But I think what we're going to have to wait for, and the real key here, is whether Kathleen Bell and anyone else actually ends up testifying. You know, cross-examination is, for the most part, just a foundation for what's going to come later. And that's all we're really seeing here in large part. A lot of this is going to be scored in terms of what follows in months from now.
Greta, let's step back for a moment and take a look at the bigger picture, if you will. How important is this witness for the prosecution case, and how important is it to prove the defense theory that this evidence was planted?
I think this witness is more important for the defense because Johnny Cochran, in his opening statement, gave a very detailed opening statement and made allegations that this prosecution was one in which a police officer planted evidence. And when you start making allegations like that as a defense attorney in opening statement, you better be able to deliver. For the prosecution, Mark Furman thus far has done a fabulous job for the prosecution. F. Lee Baily really was not able in any way to get under his skin or to make him look like a liar, with the exception, if he can produce Kathleen Bell and Andrea Terry and they're credible, that will make Mr. Furman look like a liar. But the biggest mistake I think the defense made overall is they've told the prosecution about the racism issue since last fall, and the prosecution was ready, and so was Mr. Furman.
We're told that the attorneys are now in chambers with Judge Lance Ito. We'll take a short break and be back with more of our coverage of the Simpson trial right after this. We're still waiting for today's session in the Simpson trial to begin. We're told the attorneys are in chambers now with Judge Lance Ito. While the Simpson defense team is trying to show Detective Furman carries a bias against African Americans, CNN's Art Harris reports some African Americans who have dealt with Furman are saying racist allegations against him are wrong.
I'm cheering for Mark Furman.
Connie Law met Mark Furman just 2 months before Nicole Brown Simpson and Ronald Goldman were murdered, when the LAPD detective tried to solve her uncle's murder.
In my experience, Mark Furman is a great homicide detective. Very warm, very congenial, very concerned.
A black family that paints a very different portrait than the defense.
Mark Furman never showed signs of racism to me or my family.
When Furman came under attack, Connie Law sent him a card to cheer him on. And her mother, Lily, called his boss.
I called his boss because even though I was reading these terrible things, I remembered the man that was so kind to our family.
Connie Law has been contacted by the prosecution as a possible character witness for Furman. And there's yet another African-American Furman supporter who was on the prosecution witness list until she got telephone threats and asked that her name be removed. Patricia Foy became a Furman fan after he hunted down the man who robbed her. When you told Mark Furman you'd chase this purse snatcher down, what did he say?
He told me I was incredibly brave, but I was also incredibly foolish, and that I should not do that again, because I could end up dead.
Does that sound like the behavior of a racist?
Absolutely not. Absolutely not.
But they say he's a racist.
He's not a racist. They're just trying to hang something on him so they can cover up for the defense. That's all they're doing. A racist would not take the time and the concern that he took with me.
African-American crime victims willing to defend a white cop accused of racism and worse.
We feel so strongly that perhaps this is unfair, what's been done to him, the character assassination.
I'm cheering for Mark Furman because I know him and because I want him to hurry up and get off the stand and all this be over with for him.
Art Harris, CNN, Los Angeles.
And in court, Furman is, of course, lauded and protected by the prosecution. Out of earshot of the jury Tuesday during a hearing on a new witness, the lead prosecutor once again reminded everyone of who the victims are.
The actions he took on the day in question. Let's remember this is a double homicide case. This is not a case concerning the character of Mark Furman with respect to the issues of race. This is a case involving the homicide of 2 murder victims and a junior detective who found evidence based on the statement of a witness. That's what we have here, and it's very important that we all remember that. Whatever anyone may ultimately decide about Mark Furman's personal life or personal views of the world, has nothing to do with whether or not he is credible as an officer and with the issues that relate to his honesty and veracity. And that is a much more narrow parameter than counsel would have this court believe. But the court knows better. I know the court does because the court has indicated what its rulings are based on, wisely so. We are talking about the character for truth and veracity. We are talking about whether there is a propensity to fabricate evidence with respect to interracial couples. That's what we're talking about here. And let's not forget that.
The lawyers are still in chambers with Judge Lance Ito. CNN's live coverage of the O.J. Simpson trial will continue when court is once again in session. We'll take a short break, and when we come back, we'll have a news update from Washington and Reed Collins. I'm Jim Moret in Los Angeles. We're still waiting for the beginning of the session today in the O.J. Simpson trial. However, we have received transcripts from the sidebar testimony from yesterday, and reading from these transcripts, it appears clear that Christopher Darden and Marcia Clark were both very concerned that the issue of the defense claim that Mark Furman may have a financial stake in the outcome of this trial would come before the jury. We have a portion of the court proceedings yesterday. Let's listen to that right now.
Detective Furman, for what purpose did you retain your lawyer, Robert Turtle?
Because I was defamed in the media for planting evidence in a capital crime.
Some magazine or other?
Magazine, radio, TV, personal attacks.
Now, did you authorize your attorney to send a letter to certain of Mr. Simpson's counsel threatening a lawsuit for defamation when this case ends?
Yes, sir.
Okay. Did you review any such letters before they went?
I don't believe so. I received copies, but I did not review them and approve them, no.
All right. And you were complaining that you had been accused as a result of conduct for which you thought they were responsible of planting evidence in a capital case. Is that right?
The first part of that question, I don't think I understand.
You were complaining, as you've just told us, that you were being accused in the media, partly due to their responsibility, these lawyers,
yes,
of
sir.
planting evidence in a capital case.
Yes, sir.
Okay. And that is a very serious crime, isn't it?
Yes.
Both state and federal.
Yes.
Yes. Okay. Now, when this lawsuit is over, you have an intent to begin a defamation lawsuit of a civil nature against Mr. Shapiro and Mr. Cochran, correct?
I believe so, yes.
And to ask a jury for money damages for the damage to your reputation for being accused of planting the glove.
What's the objection? No.
That's as far as I'm going.
It's the nature of the lawsuit, counsel. Overruled.
Is that not your intent?
Yes, sir.
Just to clarify, Robert Turtellow, Mark Furman's attorney, says that Mark Furman is not planning on suing the defense team, but rather the publications which spread these stories. And reading here from the transcript, Christopher Darden yesterday at a sidebar said, "My concern is," this is Christopher Darden speaking, "if the jury learns he, Mark Furman, is suing Mr. Cochran, the lead attorney on this case, that adds a whole new dimension to this case, and the jury that could very well affect their assessment of this witness's credibility," to which the judge said, "It certainly does. It certainly does add a new dimension to the case. I don't disagree with that at all." Greta Van Susteren in our Washington studios, do you want to comment on this? I know you made a big issue of this yesterday.
Without any doubt, it's admissible. It goes to credibility. Any witness, including Mark Furman, who takes that witness stand, is going to have credibility examined. It happens in every single trial. And if this witness has some financial interest in the outcome, whether it is that he intends to sue the lawyers in the case or the defendant or anyone else, that should be brought before the jury so the jury can determine whether or not that does affect his credibility. There's also the issue of animosity. If this witness has any animosity towards anyone on the defense team, the jury should hear it. Same thing with defense witnesses. If they have animosity against the prosecution, the jury should hear it. They're the ones deciding the case. They're the ones determining credibility of witnesses.
Professor Stan Goldman here in Los Angeles from Loyola Law School. What's your take on this?
Well, although it's a little different and a little more understandable, it's not really legally any different than selling your story to hard copy. That's what the prosecution is sometimes faced with in these cases, people who've turned a dime or planning on doing so by selling their stories. In this case, it isn't his story that he plans on selling, but there is something that could affect his testimony. If, for example, he did remember the conversation with Kathleen Bell, now that he has hundreds of thousands of dollars potentially riding on it, would he take the stand and be as willing to testify that he did remember it, thereby perhaps giving up a lawsuit? I'm not saying it happened, but it could.
The camera is tilting down in the courtroom. Judge Lance Ito is on the bench. Let's join the proceedings.
Good morning, counsel.
Good morning, Your Honor.
All right, back on the record in the Simpson matter. Mr. Simpson is again present before the court with his counsel, Mr. Shapiro, Mr. Cochran, Mr. Douglas, Mr. Baily, people represented by Ms. Clark, Mr. Darden, and Ms. Lewis. The jury is not present. Counsel, is there anything we need to take up before we invite the jurors to join us?
There is, Your Honor, partly because I personally represented to you yesterday that I had spoken with Max Cordova, and because you may have heard reports that he gave a conflicting statement. I want the court to be reassured that I did indeed, about 2 weeks ago on a weekend, from Mr. Cochran's office, talk to Mr. Cordova. Mr. McKenna was talking to him and interviewing. He called us. McKenna recognized his voice. They had spoken before. He handed me the phone just to say hello, as one Marine to another. I did that and handed the phone back. We reached Mr. Cordova last night, and he said, yes, that's correct. I was confused when the fellow asked me the question. But the disturbing thing is that NBC would air that statement nationwide without picking up the phone to call either myself or Mr. McKenna, whom they're perfectly able to hound when they want something. They know where we are at all the time. They could have avoided this whole mistake. And that level of journalism is sinking way below what one expects of NBC, and I'm very upset about it, and I have reported it to Dateline, and I'm expecting a correction this evening when the matter is pursued. More to the point of this trial, Your Honor, you had ruled out the testimony of Mr. Coleman, who runs the ladies' wear shop next door. I believe that if one of the inferences that could be drawn from the conduct of Detective Furman was a deliberate racial slur, that should be a jury question and not for the court to rule out because there are other options.
Mr. Furman, would you step out, please? Well,
I'm not asking the court to change its ruling.
Let me finish hearing from Mr. Bailey.
I'm taking a legal position, Your Honor, and because what we have is a letter from Mr. Coleman, in order that this subject can be properly scrutinized on appeal, in the horrendous event that should ever become necessary, I'm asking that you give me the opportunity to put Mr. Coleman on the stand out of the presence of the jury and have him tell you exactly what happened and the way it happened, so that a reviewing court can decide whether or not you've preempted the jury from deciding a question if the question as to what the conduct meant is a factual as opposed to a legal question. Second, Mr. Coleman corroborates Max Cordova, because after Detective Furman called him a nigger inside the building and followed him out to the parking lot and did it again, Cordova came to Coleman's place of business. Coleman remembers the incident and said, I had to calm him down. He was very upset, and he was very excited by the whole thing. Now,
well, that's a different offer of proof.
I understand, and I'm bringing that to your attention because I learned it a short time ago when I called to see if Mr. Coleman would be available to come down and make an offer of proof on the record. That, to me, is the best possible form, and we think it would be worth the court's time to preserve it.
How about a statement in writing? I don't want to take up the court's time doing extraneous hearings all the time, counsel.
All right. Now, if you can enable me to understand, Your Honor, you have a rather elaborate statement on the first part. Cordova, it seems to me, is a separate issue entirely.
I agree.
And his testimony would be relevant if Cordova testifies, as he told Dateline he would last night, and is attacked on the ground that he made the incident up. Other than that, I'm not sure that a prior consistent statement would be admissible. But should it be termed a recent fabrication on Cordova's part, and that's the drift I get from this side of the table, then the fact that he said that to Coleman hard on the heels, even if it's not part of the res gestae, would become admissible under California law. I don't think that question is going to be presented to you as to the Cordoba part, unless and until that attack is made. I do think that I would like a better form, and if you're suggesting I rewrite or we put together a new, more formal statement, since those were all Mr. Coleman's words, pinpointing the issue that we wish you to take another look at, perhaps. I'll be happy to do that rather than take up the court's time putting him on the witness stand. I don't think it would take long, but I'll be happy to pursue that.
All right, I think you have the direction from the court.
Okay. Now, in addition to that, Your Honor, we have a case that we would like the court to consider. It is a court case that was thrown out because Detective Furman lost a door in which a bullet hole was supposed to be, called the Gould case in the Superior Court. We believe that his conduct in that case is relevant to this one. We're going to ask you to take another look at the Britton case on which you previously ruled, perhaps with some additional facts. Beyond that, Your Honor, the phones are ringing and ringing hard. People calling in who watched the detective and now wish to offer evidence contradicting his claims. And as these people come up, as rapidly as I can, I will submit them to the court as a proffer, the way I did originally, and then await your direction as to what, if anything, must be turned over. But this is an ongoing process, and I expect it will continue for some days.
All right, thank you. Ms. Clark.
I think I'd like to play a tape for the court. Because not only did Mr. Baily make a direct misrepresentation to the court yesterday, he's done it again this morning. And I think that the, as I said yesterday, as I predicted, the tape would be very illuminating and provide the court with some very graphic evidence of the way counsel takes his role as an officer of the court so lightly. I want to play this tape now so that the court will be reminded of exactly and precisely the language Mr. Baily used yesterday when he sought to misinform and mislead this court as to the nature of his contact with Mr. Cordoba.
All right, Ms. Clark, what is this a tape recording of?
I'm sorry?
What is this a tape recording of?
His appearance in court yesterday, in which he stated to this court, in which he stated to this court that he had a conversation, Marine to Marine, with Mr. Cordoba, and that Mr. Cordoba told him, not Mr. McKenna, him, the statements that he later reported to this court.
You're referring to the comments by Mr. Baily at 18606, beginning at line 15.
We don't have a transcript, Your Honor.
We don't either.
Yes, you do. '606. 18606, starting at line 15.
You okay, Mr.?
I'm sorry? Mr. Carpenter?
Mr. Darden and Miss Lewis about this incident, and they shut him off. They said, we're only interested in what Miss Bell said. And that's what he will testify to. And, Your Honor, I have spoken with him on the phone personally, Marine to Marine. I haven't the slightest doubt that he'll march up to that witness stand and tell the world what Furman called him on no provocation whatsoever. As far as discovery is concerned, there is no written statement. There are no notes that I know of. And I heard about this because he called us wanting to make it known that these people had tried to suppress this information. I spoke to him personally. I don't ever take notes, and I didn't on that occasion. All right. That is not what Ms. Clark says. I said I did not claim that he related the incident to me. I said I spoke to him, and I have no doubt that he'll appear, and I don't have any doubt.
All right,
this is the kind of nonsense that gives lawyers a bad name, Your Honor. You know, it's very clear what he said to the court and what he was intending to convey. He was intending to convey to the court that he had personal knowledge of what this man said because this man said it to him personally, Marine to Marine. And now he's standing up and hair-splitting with us. I never said he said this to me. I just said he spoke to me personally. That's nonsense. That shows you what we have over here in the way of ethics on this side of the table. They'll get up and they'll misrepresent to their heart's content until they get caught, and then they have excuses. And then they start splitting hairs. And then they have, well, this means this, and oh no, that means that. I feel like we're in Alice in Wonderland. We've got Jabberwocky here. Nothing means what it says it does. No means I don't remember. I don't remember means no. Same thing, now it's coming out of the mouth of Mr. Baily. But that's exactly what we can expect to happen when the witnesses take the stand. If we rely on his offers, and we have not been able to reach Mr. Cordoba, we need to talk to this man personally. I can assure the court, absolutely. No one cut Mr. Cordoba off. No one refused to listen to him. As a matter of fact, Mr. Darden kept it, tell us more, tell us more. Please, is that all you have? Is there anything else you want to tell us? And with respect to Mr. Cordoba's prior statements, they've been aired on national television. I mean, if Mr. Baily doesn't know what he's said before, I guess he's never turned on his television set. But they're a matter of record that all the world has seen. So if he is now claiming to have heard something as volatile and inflammatory as what Mr. Baily is representing, we do have some serious impeachment. But no one cut that man off. We did not have the opportunity to speak to him, so we do not know exactly what he has, what he's going to say at this point. I certainly do not feel comfortable accepting anything that that Mr. Baily offers to this court, especially in view of what we've heard. And I would like to play the clip for the court from Mr. Cordoba, because Mr. Cordoba, when given the opportunity to say, I spoke with a member of the defense team, I spoke with an investigator, and then someone else came on the line, said nothing of the kind. And I think that that's something that is not a matter of our record. I think the court needs to see that, because Mr. Baily, you can see how agitated he is, has been caught in a lie. And you know something, not in this case, you don't get away with that. There's just too many people watching.
I object to the lack of foundation for this tape. Excuse me, don't play the tape while there's an objection. If Miss Clark is going to take the stand and authenticate the tape, let her do it. But tapes are not self-authenticating. We've had no chance to see it, as you always require, before we're allowed to show anything to you. And I'd like to know where it came from and what it represents.
It's not before you can show it to me, before you can show it to the jury.
Right.
All right, Ms. Clark,
I'm just showing you to the court, if you please, Your Honor. It's self-authenticating. The man on it says he's Max Cordoba.
Well, no, we've gone through the self-authenticating argument before, which I did not accept, if you recall. But, being that as it may, what is this?
This is the tape of an interview with Dateline, which was conducted yesterday after Mr. Baily made his representations that he had spoken to Max Cordoba. After he made those representations in court, Dateline went and interviewed Max Cordoba and asked if he had had an interview with Mr. Baily, Marine to Marine. And Mr. Cordoba said, no, I did not.
Which answer is correct?
All right. Do you have an extra copy, by the way?
Partner to solve this mystery.
That's Bill. That's Bill Cosby, Miss Clark.
I'm aware of that, Your Honor.
Right.
We're not offering Bill Cosby at this time. And while he's queuing it, Your Honor, if I may request that the notes Mr. McKenna surely must have taken as a responsible investigator of that interview that we now learn occurred, which obviously Mr. Baily did not want us to know yesterday. We want the notes of Mr. McKenna's interview with Mr. Cordoba yesterday.
No, Sean.
You know, it's interesting that other states have rules of reciprocal discovery that require at least some offer or indication of anticipated testimony in their reciprocal discovery statutes, which is something California does not have.
I find it interesting, though, that it would appear the investigators for the defense in this case have prepared reports and taken notes on all other witnesses, but surprisingly, nothing on this one.
Well, I assume that's something you'll cross-examine on.
Probably fair to assume. Well, it makes Mr. McKenna a witness at the very least.
And Ms. Clark, who tape recorded this for you?
Excuse me? Our Media Relations Department did, Your Honor. After contacting Dateline to find out when the interview was conducted.
And are you representing to the court that this is a videotape of the Dateline broadcast? When?
Last night, Your Honor. This is a videotape of the Dateline broadcast last night, an interview that was conducted with Max Cordova after Mr. Baily's representations to this court yesterday concerning his contact with Mr. Cordova.
Is that Max Cordova? That he'll march up to that witness stand and tell the world what Furman called him on no provocation whatsoever.
No, I have not talked to F.B. Baily.
If you believe Max Cordova, and the defense hopes you will, then Simpson's defense team has some explaining to do. Because today, in our exclusive interview, the ex-Marine and potential witness said he didn't know what F. Lee Baily was talking about. That if he'd spoken to the famous attorney, he'd remember, and he doesn't.
Never talked to him?
No.
You know who F. Lee Baily is?
Yes.
Pretty distinct fellow.
Yeah.
Pretty distinct voice.
Correct.
So you haven't talked Marine to Marine to F. Lee Baily?
No.
But Cordova told us he does remember talking to Furman. And what he now says Furman told him ignited a heated debate today in the courtroom.
Max Cordova wanted to tell Mr. Darden and Miss Lewis about this incident, and they shut him off.
That representation will be disproven as well. Now, Mr. Cordova had the opportunity to say, well, yes, I had some brief conversation with Mr. Baily, but we didn't discuss the content of my testimony. Or, yes, we had a brief contact. He said hello to me. Mr. Cordova said none of the above. He had the opportunity as well to say, Mr. McKenna spoke with me. I know he's a defense investigator. He did not say that either.
All right, Ms. Clark, let's assume, for the sake of the argument, that what you say is correct, that this misrepresentation has been made to the court. What action or sanction do you seek as a result?
I think that the witness should be precluded from testifying. I think that Mr. Baily should be cited for contempt and fined substantially. As an officer, an officer of the court, he has lied to this court. He is impeached by his own witness.
I ask that you put a stop to it. Either put Cordova on the stand
Mr.
or
Baily.
stop her from testifying.
Stand up and speak when it's your turn.
Mr. Baily, do not interrupt counsel. I understand this is a volatile issue, but it's a big problem for the court. I'd ask you to control yourself, sir. Ms. Clark.
I think that what has occurred is very serious. And I think that the interview with Mr. Cordova makes it's very stark. There are no gray areas here. This is not a matter of hair splitting anymore, as Mr. Baily got up to represent to the court this morning. Mr. Cordova was confronted with the statement that Mr. Baily made, that they spoke. He said, no, we did not, and I would remember. And there was the opportunity to say we had some conversation, and he did not do so.
All right, thank you, Ms. Clark. Mr. Baily, do you wish to respond?
I do, Your Honor, and I do not appreciate being called a liar in any court, and I will ask at the proper time for correct action to be taken against the offender. The proper way to proceed, if there was any claim of misleading the court, would be to put the witness on the witness stand under oath and let him be questioned in the court's presence. What they eliminated from the tape that I saw on NBC News this morning was that Stone Phillips said, why didn't you mention these things before? He said, I only give very narrow answers to every question. As he explained to Mr. McKenna last night, he did not have an interview with me, nor did he tell me his story. When he was talking with Mr. McKenna in the office, Mr. McKenna handed me the phone to introduce me, and I said, Max, as a Marine, I'm proud that you have the courage to come forward and say this. I know that it's painful. And he said, I'm willing to do it. And my comment to the court was in response only to the unfounded irresponsible and false assertion by Miss Clark that Cordoba would never appear. She had no basis to say that whatsoever, as she has just shown with her own videotape. Now, I expect NBC to correct it, and somewhere down the line, I hope that this court record is made plain. Mr. McKenna is sitting right here, and he is available to get on the witness stand and assure the court that Max Cordoba said last night, okay, I now remember I spoke briefly on the phone. That's not an interview. Phillips could have saved himself some embarrassment if he'd bothered to pick up the phone and call me. NBC always finds me when they want to.
I am concerned, though, Mr. Baily, that the statement, I have spoken with him on the phone personally, Marine to Marine, that sort of connotates something more than just, hi, how are you? I'm glad to talk to you.
I don't understand why you're concerned. You raised no question about what was said. I was simply, if you were reading the transcript correctly, giving you my assurance that I expected him to appear when called, that he was under subpoena, and that I did not think he would vanish, and that I had spoken to him and received an assurance on that alone. I do not interview witnesses. Good lawyers generally don't. They might be in a position of having to testify if the witness were to accuse them of something or tell a different story. Mr. McKenna is employed for that purpose. We happen to be in the same room when Cordoba called us, as his phone record will show, if he has made the call from a private phone and was billed for it. Now, you're perfectly able to explore this right now with Mr. McKenna, and I wish you would. And if you read the transcript carefully, I was reacting to the only thing that concerned me, because an offer of proof is an offer of proof, and the court has to accept it as that. But the court might be concerned that if cross-examination were put forth and the witness never appeared, that the damage would be done and you couldn't unring the bell. And it was my purpose to assure the court that I felt this fellow would appear based on his statement to me that he would. And that's all that transcript says, and you can't read it any other way. If you've got a contrary impression, I'm sorry. That was not my purpose. I wanted you to know that I believed he would appear, or I wouldn't put the questions. And that is the sum total on the subject.
All right. Thank you, Mr. Baily. All right, counsel, we have an interesting situation here, not unexpectedly. Counsel, what we're going to do with regards to Mr. Cordoba. Ms. Clark, where does Mr. Cordoba reside?
I'm sorry?
Where does Mr. Cordoba reside?
He's not in the state, or he wasn't last night. We were unable to contact him.
What state does he reside in, Mr. McKenna?
He's not in California, I don't believe today. He resides in Bellflower, if that's a town. He has a subpoena.
When did he leave?
I believe he left either this morning or last night.
And when did you speak with him?
I spoke to him.
All right, Ms. Clark, I agree with Mr. Baily's comment that television news broadcasts are not bases for the court to preclude at this time the offer of Max Cordoba as a defense witness. Unless and until I hear testimony from Mr. McKenna and Mr. Cordoba himself regarding these issues. I think you agree with that. So at this point, I'm going to preclude any cross-examination regarding anything with regards to Max Cordoba, which I had previously done, but I'm going to extend that prohibition through the remainder of Detective Furman's testimony. Under the California Evidence Code, a prior inconsistent statement may be offered as long as a witness has not been released from the requirement of providing further testimony under 770 of the Evidence Code. So if it should transpire that Mr. Baily is correct in his assertions, then perhaps we will hear from Max Cordoba. But unless and until I'm satisfied that the offer of proof there is a sound basis for it, I don't believe Max Cordoba will surface. But I'll determine that at a later time.
Thank you, Your Honor. Mr. Darden needs to address the court on the matter of Alwyn Martin.
Well, I was going to ask whether I could ask questions about Alwyn Martin, because they had a tape-recorded interview with her last night, we're given to understand. But I would like a clarification of what the court is saying. You don't know whether Max Cordova is going to surface because you don't know if he will repeat what he said on television?
No, what I'm saying is that as far as this controversy
Yes.
that has since arisen, I'm not going to allow any cross-examination with regards to anything Max Cordova might or might not say unless and until we hear from him first, because there are some issues we need to resolve before he hits the witness stand in front of the jury, is what I'm saying.
Now, he's in New York for 4 days, I'm told.
Well, I suspect the defense case won't start any time between now and next week.
Are you saying that you will postpone examination of Detective Furman on the Cordova issue until the defense case has begun?
That's correct.
Well, I strongly object to that, Your Honor. You have the power to get Cordova in here while the prosecution's case is going on and hear from him and make your preliminary findings. But to put it that far down the road is completely unfair in the cross-examination of this critical witness.
Well, counsel, I didn't create this problem.
I didn't create it either, Your Honor. We interview witnesses, we make proffers to the court, and that's all we have done. We subpoena witnesses. That, too. I didn't interview him for Dateline or ask him to talk to Dateline. Nor did I confuse him as to whether or not he'd ever talk to me. What are we being penalized for? I don't understand.
You're being penalized at this point merely under the procedure of the California Evidence Code, which says prior inconsistent statements can be offered in one of two ways. Either the witness is confronted or the witness is still available to be cross-examined. And that's how we're going to do it. Thank you, sir.
All right, note our objection, please.
Noted. Mr. Darden.
Good morning, Your Honor. Your Honor, the people would like to lodge a 352 objection to the admission of any information relative to Detective Furman's contact with Alwyn, A-L-W-Y-N, Darla Martin. Miss Martin was the victim of a carjacking on May 20, 1993. During the commission of that assault and robbery, she apparently was stabbed. She was taken to the hospital where she was treated. She was taken to surgery. 2 days later, Detective Furman visited her at the hospital, as I understand it. When he walked into the room, Miss Martin's boyfriend was there. Miss Martin is Caucasian, as I understand it. Her boyfriend at the time was African. I think he was British, actually, so not necessarily African-American, but of African descent. Detective Furman met him. They shook hands, introduced themselves, and Detective Furman had a conversation with Miss Martin relative to the description of the carjacking suspect. Last night, one of our DA investigators, Brian Hale, interviewed Miss Martin. Miss Martin could point to no racial epithet uttered by Detective Furman. She could point to no racial slur. Detective Furman did not tell her that only blacks or African Americans commit carjackings. Detective Furman did not tell her that he disliked interracial couples or that race mixing was a crime against nature or anything of that sort. We've reviewed the file, the investigative file in this case. There's nothing in the file to indicate that Detective Furman harbored any type of hostility or animosity toward Miss Williams or her boyfriend because of their relationship. There's no evidence. I'm sorry, Martin. There's no evidence, no indication, no firm evidence, no firm allegation by the witness, Miss Martin, that Detective Furman has done anything but act professionally. I don't know why the defense wants to introduce this incident or this contact, but I can assure the court that there is nothing here which suggests that Detective Furman harbored any racial animus or bias against Miss Martin or her boyfriend because of their interracial relationship. I'm at a loss to explain or understand why they want to introduce this. It shouldn't come in. It just shouldn't come in. I'm sure that once counsel begins asking his questions relative to this issue, and once he puts his own spin on it, that perhaps he can somehow transform it into a racial issue. But based on our conversation last night with Miss Martin, there is no racial issue here. There's no evidence at all that Detective Furman acted in any way other than as a professional police officer.
All right, Mr. Baily.
First of all, I'd like to hear the tape. Mr. Darden has chosen not to confront the offer of proof in any way. You were never told in writing or in any oral description by me from this podium that racial epithets were used or any of the other things he's attempted to negate took place. What you were told was that Detective Furman was assigned to investigate a stabbing and a robbery of an automobile. That pursuant to that assignment, he came to the hospital to interview the victim, who had been injured in the stomach with a sharp instrument. That she told him the assailants were white, that he suggested that they may have been light-skinned blacks. And when she refused to budge on that issue, he left the room, filed no report, and never returned. That was the offer of proof. I have not heard that contradicted. But because we're having these problems, I would suggest that the court listen to the tape that was made last night and that we make it part of the record. If you're relying to any extent on his interpretation of what he thinks someone else heard from Miss Martin, the court needs to hear it directly. And then if the offer of proof is somehow improper, you have a chance to catch it right now. But the tape is the best evidence, not Mr. Darden's spin on that tape. And I think we should hear it.
Mr. Darden?
I'd like to hear their tapes, Your Honor. Our tapes are impeachment evidence. I don't know what Mr. Baily has been reading, but apparently he hasn't read the complete police file in this case. Detective Furman did file a supplemental report. And not only did he file a supplemental report, he also took to Miss Martin a mug book containing many, many white arrestees and potential suspects, all Caucasian. Detective Furman did his job, Your Honor. Now, he questioned Miss Martin apparently about her description of the suspect, as any detective would do. Where's the racial issue? Yeah, there is none. Mr. Baily perhaps should get the rest of the police file in this case. And once he does, he'll see that Detective Furman attempted to run down partial fingerprints recovered from her vehicle. He took her mug books. He looked at other reports, okay, to see if there was some type of MO between this carjacking and others. He did everything a police officer is supposed to do in a case like this.
Do you have that file here, or a copy of it?
I have a copy of the supplemental report on it. Well, that's being done.
Your Honor, might I point out that Miss Martin called Detective Tapia, the West Los Angeles Police Department, to ask for the report, and he sent her 2 pages and said that's all there was. Furthermore, I'm startled to learn today that the prosecution has so many facts on the Martin case. They were very silent about them yesterday when we first discussed this issue. Perhaps this is something that Detective Furman never mentioned until after we talked about it.
You know, we weren't particularly concerned about the Alwyn Martin case, Your Honor. Why should we be? There's no issue of racial animus contained in this case. At any event, before counsel stands before the court and makes these allegations of this nature, he ought to check out the facts. He ought to know what he's talking about. In addition, Your Honor, LAPD does not turn over unsolved supplemental investigative reports to victims or to anyone. This case is not closed. This case is still an open case. And I would ask the court to direct counsel not to distribute the supplemental report to anyone, and that no copies be made as well. There was a partial fingerprint recovered from the victim's vehicle.
While Christopher Darden argues over whether the defense should be allowed to question Mark Furman about another witness, we'll take a short break and be back with more right after this.
Today on Talk.
Judge Ito is now reading from a report prepared by Detective Mark Furman, which the prosecution intends to show that Furman is not a racist with respect to his activities with a specific witness.
Has no access to police reports, particularly when she's told they don't exist.
All right, I find the offer of proof to be clearly contradicted. Prosecution objection will be sustained.
Your Honor, if I can be heard, relative to the issue of the follow-up investigation.
And I'll mark this as Court's Exhibit 7.
Okay. Your Honor, will the court kindly order defense counsel to return the supplemental reports to the court, and will the court seal the supplemental reports?
Yes.
The judge has just ruled that the defense may not cross-examine Detective Mark Furman about Alwyn Martin, a witness the defense intended to show to offer proof that Mark Furman was a racist. Also, the judge has ordered that he will postpone the cross-examination of Detective Furman regarding Max Cordoba until the defense case has begun, and that is once the prosecution has rested its case against O.J. Simpson. Greta Van Susteren in our Washington studios. 2 blows to the defense here, clearly, with respect to the cross-examination of Detective Mark Furman. The scope is getting smaller here, isn't it?
And it's very tough for the defense because that is the linchpin of their defense, that the prosecution witnesses lack credibility and that this officer is a racist and that this racism led him to plant evidence against O.J. Simpson. It's clearly a blow for the defense.
Stan Goldman, we saw a very passionate argument by Marcia Clark. She feels clearly as if the prosecution has once again been duped by the defense. Don't you agree?
Well, it may just be unfortunate, but everybody in the country believed that F. Lee Baily was saying yesterday that he had in fact interviewed this Mr. Cordoba, and Mr. Cordoba would be coming to court to confirm the statements the defense were claiming he was saying. When we read the very wording of his statement, it's clear that there is some error in there. He may not have been actually saying that. But I think at the moment, at least, Judge Ito is very upset with the possibility that there was a lie by Mr. Baily yesterday, and he's meted out a fairly harsh punishment here. They cannot, for potentially several months, bring up again the question of Mark Furman's racism.
Very aggressive and passionate arguments by the attorneys outside the presence of the jury. We'll take a short break and be back with more right after this. F. Lee Baily is at the lectern. He has offered 3 items that he wishes to use during cross-examination of Detective Furman. 1, a small flashlight, which is said to be similar to the flashlight Mark Furman used at the murder scene and at O.J. Simpson's house. 2nd, a brown leather glove in a Ziploc bag similar to the one reportedly found by Furman at O.J. Simpson's house. And 3rd, he wants to ask Furman on the stand who his 3 best friends were. And F. Lee Baily reminded the court that this question was allowed to be asked of defense witness Rosa Lopez. Stan Goldman, your brief comments on these 3 items?
Flashlight, Your Honor, no objection.
Well, with respect to the flashlight, the defense is trying to show that it would have been a minor miracle to be able to spot all the evidence in that dim pre-dawn light with such a small flashlight, the tiny speck of blood on the Bronco, the glove.
Let me interrupt you just for a moment while Marcia Clark makes her responses. I'm sorry.
A different make, a different style that has no relevance to this case either. Yes.
When you say different size, what do you mean, Ms. Clark?
Judge Ito is now examining the glove which F. Lee Baily seeks to show Mark Furman, and you saw that it was in a Ziploc bag as F. Lee Baily wished to present it. The judge is inspecting it right now.
This is, under 352, there is no valid probative purpose to this. I'm sure the court knows that what Mr. Baily again intends to do is make another inflammatory argument with no evidentiary basis whatsoever in an attempt to confuse, mislead, and deceive this jury. This has no part in any search for the truth. This is a fantasy woven by the defense for which there's no evidentiary basis, no logical or factual connection to this case.
Let me ask you this. What is the glove size that is on the glove that was recovered at Bundy?
Extra large.
The glove there is a Brooks Brothers size small.
Right.
They were out of extra large, Your Honor.
Not only that, but the glove in issue is an Aris, and it is not a Brooks Brothers. Can't even tell if it's a man's or woman's glove. Size small. I guess it's Mr. Baily's. I don't know. what the relevance is to this case, Your Honor. I can't see any possible valid evidentiary purpose for the admission of such an item that bears no resemblance to the gloves in this case, or a Ziploc bag that has absolutely absent from this case, no such evidence in this case whatsoever. And I think that the court should prevent these kind of theatrics that are misleading and inflammatory and deceptive in front of this jury.
What's your comment on the letter regarding Detective Furman?
With respect to that, I'd object to the admission of the article. With respect to the letter itself, I have a real difficult time seeing the relevance of that, Your Honor. Detective Furman has sought legal assistance for the purpose of defending himself as a result of the malicious attacks that have been made on him by the defense. In that regard, his lawyer attempted to defray some of the costs of his legal expenses. This was not a letter drafted by this witness, by Detective Furman. It was a letter that went out by his lawyer that this witness apparently is not even familiar with enough to say what's in it or not in it. So that alone, I think, should preclude the use of it. I don't see its relevance in this case. It does not show any financial interest in the outcome of this case that would be relevant to bias. So I think under 352, that letter is of no probative value at all. I should also indicate that Mr. Baily has given us no proof, no offer of proof even, as to how Detective Furman, which I'm sure is the inference that he wants us to draw, put the glove that he found at Rockingham into a plastic bag. There's no offer of proof. There will never be any proof. There will never be anything but Mr. Baily's theatrics, dramatic, albeit eloquent statements to this court that are absolutely empty of any evidence or any factual support. And that is why he is seeking to take a different pair of gloves, different style, different size, in a Ziploc bag that this case does not contain. There is no Ziploc bag in evidence in this case. He's manufacturing evidence. He doesn't like the truth, so he's manufacturing his own. And that's what this is all about. And that's why this is the kind of thing that should not be permitted. May I have a moment, Your Honor?
Certainly.
Stan Goldman, we see a different type of glove, different size glove that F. Lee Baily wants to use. Is this a fantasy, as Marcia Clark characterizes it?
Well, whether it's a fantasy or not, it was a big mistake by the defense not to have the same size glove. It can be excluded for that minor reason, even if the judge would have admitted it originally.
Going to seek to allow, is the court going to allow counsel to use the actual letter?
I don't know yet.
Or neither?
I don't know yet.
You don't know yet. I think that as far as the letter goes, I think we've gone as far as we need to go. Detective Furman indicated he was aware of the letter. He did not draft it. He's unaware of the precise contents of it. It was an article drafted by his lawyer. But counsel has received the admission from Detective Furman that he sought.
Greta Van Susteren in Washington, your comments on what's happening here with these exhibits that F. Lee Baily is proposing to use during the cross-examination?
Jim, if you're going to use exhibits that are facsimiles of something in the case, you better use the exact one. As Stan said, it's not just unfortunate, but it's a mistake by the defense not to scour the countryside to find the right size glove, because you're not going to convince a court to introduce something that is distorting what is part of the case, and that's the mistake. They've got to find the right size glove.
And just to point out, with regard to the flashlight, Marcia Clark made no objections for its use.
With respect to the letter, I think no. I've said it. With respect to Detective Furman and the plastic bag and the glove that counsel now wants to admit, there is absolutely no evidence that Detective Furman put anything in any plastic bag on any time relevant to this case, June 12th, June 13th, or June 28th, or July, August, September, October. None. And so there is no valid purpose for the admission of that non-evidence.
All right. Mr. Baily, any brief response?
May I respond to that, Your Honor? I take it there's no issue as to the three good friends. Just a couple
Yes.
of things.
Oh, I'm sorry. I forgot to address that. Allow me, please, counsel. With respect to the three good friends, Your Honor, Number one thing, we have a privacy issue as to those 3 people. I wonder if it's fair to have their names aired publicly for no valid purpose. With respect to the cross-examination of Rosa Lopez, I mean, this seems to be this kind of like a petty tit for tat. You did it, so we get to do it. They obviously don't understand. Mr. Darden was cross-examining Rosa Lopez because she claimed to have witnessed something very important, very significant concerning this case. And obviously, it would be logical for one to expect that she would tell that very significant observation and experience to her closest friends. And so that went to an important area of impeachment. What is the valid purpose of inquiring of Detective Furman who his best friends are? There is none. This is just a petty, vengeful kind of tactic employed by the defense. If the court is inclined to allow for this kind of nonsense, then at least allow Detective Furman to write them on a piece of paper and allow counsel to see those names. But I think there is no valid purpose for this. I really think it's just a petty, ridiculous kind of form of payback by the defense. There is no valid evidentiary purpose to it, as there was in the cross-examination of Rosa Lopez. I would like for counsel to perhaps give this court an offer of proof as to the relevance of Detective Furman's 3 best friends.
But I suspect Detective Furman's 3 best friends would be proud to be stand up and be counted.
I'm sure they would, Your Honor. I just want to give them the option of doing so. But if counsel wants to, you know something, as the court is well aware.
Why don't you ask Detective Furman if he has any objection?
I can.
And I would suggest, this is something that in most cases they're entitled to look into. Obviously, the people you want to talk with are the people who know the person the best.
Right.
If Detective Furman has no objection to revealing that privately to you and to counsel for investigation purposes, then it's a non-issue.
I'll be glad to handle it that way. It's just that, we are all sensitive to the privacy issues that have been foisted upon us, and I just don't want to do that without anybody's say-so ahead of time.
All right, well, let's pursue it that way.
All right.
All right.
Your Honor, the letter Mr. Baily alluded to a moment ago is here, and the clerk is making copies of that letter.
All right, thank you. Mr. Baily?
Let me address the other issues and save that one until I get the letter.
All right.
To actually see it. The transcript, if it pleases the court, page 18, 750 and before, shows that the witness knew about the letter. It was unclear as to his understanding of all of its contents. The flashlight is solved.
Yes.
Let me state very clearly, and I should point out that if Miss Clark thinks that hand and this glove would ever work together, her eyesight is as bad as her memory. But Marines, if it please the court, have a habit most of them acquire as to where they carry things because of the nature of their duties, drills and activities, and the nature of the issued garments that they wear. The prosecution has opened this door rather deliberately, knowing full well that there would be questions as to whether or not the someone, and there has to be someone, who transported that glove to Rockingham could have been Detective Furman. They were at pains to have Detective Phillips say that he never wore a coat or almost never wore a coat, suggesting that he would not have had the means to conceal the suspect glove had he acquired it. A generous offer would be to use both, the bulk of which exceeds the large glove that will be in evidence if they ever get through testing. The plastic bag, I think, is reasonably similar, and the witness can tell us, to those contained in the homicide kit in the car that he was driving that night, or riding in. The rubber glove, which is here for a different purpose, is similar to the one that we have seen on Detective Lang and that Detective Furman said was in the homicide kit and available to him. We have suggested that he has described with great differences a key trip to the body of Ronald Goldman. We suggest that most killers don't leave one glove at the scene and carry the other one to private property under any circumstances, and I suspect that every detective who's asked if he's had that experience will have to say no. So the likelihood is that when the killers left the scene, both gloves were there or both would have been taken. You have seen that the one glove, which is admitted in evidence, was under some leaves and not easily visible until the leaves were poked back. Detective Furman described that as leaves cascading down over the glove and partially blocking the view of it. Assuming, since that glove is right against the fence, that the other one was seen several feet away, from the vantage point on the north side of the fence, in the shrubbery, where it would not be immediately visible unless specifically looked for with a flashlight. If that was spotted, even with this little light, which throws a pretty good spot for a short distance in darkness, how was it transported to Rockingham? Certainly the prosecution is going to ask that question. If it were placed in a bag, which would explain the reason that it didn't dry, and we will offer evidence to this court that had it been sitting out in the air at 60 degrees under the conditions which existed that night, it would have dried, and that will be given by someone who has seen the glove and the amount of blood on it and is an expert in such matters. So, one way to explain its failure to dry would be to have it sealed off from the air. Detectives frequently, as we have seen in this case, collect evidence in plastic bags, something you are never supposed to do if you're dealing with blood, because everything that plastic bags do, as you will recall from an incident in the courtroom, to bloody objects is bad for evidentiary and detection purposes. Marines tend to carry things in their socks, the same way some detectives carry an ankle holster for a backup weapon. This package could easily have been kept in a man's sock, short or tall, for the length of time that would have been necessary from the finding of the glove, if it occurred when we believe it did, on his visit to the north fence, described in dramatically different ways on two different occasions, in ways that can't be reconciled. It could have been concealed up to the time that he bolted out of the house without telling anyone and making sure everybody else was occupied, and for 15 minutes did something which we believe explains the presence of the glove, the blood in the Bronco, etc. And we ask Your Honor to note that this man said that for 5 to 7 minutes he investigated the side of the house, wondering who dropped the glove and where he had gone, and failed to notice a set of steps and a door leading into the house. If that does not contradict any possibility that he occupied his time, as he says, I can't imagine a stronger contradiction. A door is hard to miss. And Mr. Furman has experience with doors, as we will show you in the Gould case. Now, based on all that circumstance, I think it fair to ask Detective Furman if it would have been possible for him to put a glove in a plastic bag to which he had access and to stick it in his sock and to later pull it out and dispose of the plastic bag. Not a complicated question, not one he'll have trouble understanding, but a fair question, it seems to me. Because at the end of the day, the jury is going to have to decide between the choices given them, whether this defendant jumped over a fence or did something unreasonable and dropped a bloody glove on his property, whether a killer wishing to divert the police, and if this happened, he was eminently successful, from any attention to him, deposited the glove simply by throwing it over the fence, as is easy to do from the property where Rosa Lopez lives, or whether Detective Furman, who well could have, and had the motive, and we say the opportunity, carried that glove, from where he found it at the crime scene and deposited it in a way that would accomplish two things. Number one, it would keep him inexorably in the lawsuit, and number two, it would punish a black man who had the temerity to associate with a white woman in a romantic way. Now, that's the theory of the case, and I think that the evidence that we're offering to support it ought not to be excluded. I think the question goes to the weight. If Detective Furman wants to say, the kinds of socks I wear are so fragile that they wouldn't have carried the package, that may be his answer. The question is, are we entitled to ask? As to the letter, I'm holding, I believe, does the court have a copy? Let's
yes.
All right. It is a letterhead specially made up for this case, and it says Mark Furman Justice Fund. It seeks financial contributions, and I respectfully suggest, Your Honor, that it's admissible for several reasons. First, Detective Furman knew about it, and it was to his financial advantage if others would pay his legal bills so that he wouldn't have to. Number two, unless and until Mr. Tortolo can provide some evidence that the expenses, not fees, but expenses of handling Mark Furman's representation in this case had caused him to spend $100,000 of his firm's money, as this says, then he has committed a rather neat violation of Title 18, Section 1341, mail fraud, by trying to induce people to pay money on the ground that $100,000 had been spent. And if Detective Furman knows how that money was spent in representing him, in this case by Tortolo and Butler, I think he should be able to tell us. And if he doesn't know, then he should tell us whether or not he ever questioned this assertion before this letter was put in the mail to his fellow police officers to induce them to depart with their hard-earned income. I think that would be fair cross-examination, and that is the basis for further questions about this letter.
All right. Ms. Clark, you want to address just the letter, please?
Only the letter?
Yes. That's the only thing that we haven't discussed.
Now that I finally read the letter, Your Honor, now I'm really stumped as to the relevance. I cannot see how, I mean, counsel has already gone into the existence of the letter. Probably should not, I should have objected to it at that time. And now that I see the letter, I can tell the court, absolutely, I do not see the relevance of this. Detective Furman has an attorney who is representing him. This does not give Detective Furman a financial interest in the case. This is supposedly to defray costs, but it's really gotten way off of the end of the scale of relevance. What is the probative value for which it's been offered? I haven't even heard of a theory proffered by counsel that would make this relevant to Detective Furman's credibility. This is a letter drafted by his lawyer. He was aware that such a letter was drafted. He himself did not draft it. He himself received no money as a result of it. As a matter of fact, the understanding I have is that there has been no money received as a result of this letter. I think that there's simply no relevance to this. You know, there shouldn't have been cross-examination. As a matter of fact, what the people would like to do is simply ask the court to strike the questions and answers that have already gone and pertain to this letter as irrelevant, and not admit this letter itself, which is the height of irrelevance. I don't see the probative value with respect to the testimony of Detective Furman.
All right. Thank you, counsel. All right. The issue before the court is what can counsel use with regards to these items for the cross-examination, continuing cross-examination of Detective Furman. There being no objection to the flashlight, the mag light, that will be allowed. Court will sustain the prosecution objection to the use of the gloves for this reason. The glove involved in this case is an extra large glove. Its specific bulk and dimension, as mentioned by the defense theory, is therefore critical to how it could be transported by Detective Furman, given his garments that particular evening, how he was dressed, and what means he had available to him. I will preliminarily allow the plastic bag, however, to be used if, Mr. Baily, you can establish a foundation that a similar bag of similar size was available to Detective Furman in the homicide kit. And as to the letter, I'm going to reserve judgment on that. I would like to read it sentence by sentence, and I don't have the opportunity now. I'd like to at least proceed with what you have left with the jury this morning.
That's fine, Your Honor. I take it you will go to 12 and perhaps be prepared to address these matters this afternoon if we're still going. All right, well, in the event I should conclude cross with the postponements that confront me, and redirect is begun because you wish to use the jury's time profitably, I would like, once you have ruled, to be able to come back and complete the cross.
Yes, as to this letter, this letter, correct.
Last matter, Your Honor, the letter that was furnished to me, and this may be a copying fault, is blurred on the line that recites the amount claimed to have been expended.
It does. It does on my copy as well.
Do we have a copy where the figure 100,000 is clearly shown?
Baily, the copy delivered to me this morning in court, and
can we agree it's 100,000, or should we get the original from?
Let me make a call.
All right, well then all the more reason to delay recross as to this issue.
It's over 100,000 in the exact words.
All right, well let's get a clean copy of this, if it's available.
Your Honor, may I make inquiry of the prosecution as to whether either the left or right-handed glove that was actually involved in the murders, we believe, is accessible. The reason I tried to buy one is because we have told they were still being tested somewhere, but it seems to me if either one is available, the bulk would be sufficiently similar to make the question fair.
But this is a Eris brand gloves are commonly available. I mean, that's a major brand of gloves. I assume a similar glove is available commercially.
I thought this was Dan Marino's glove, the Isotoner or something like that.
Ms. Clark, what brand is it? I thought you told me it's Eris.
Eris Isotoner, okay.
Broadway.
Well, if we can get an extra large glove not used in the murder, would that be fair?
Yes. It's the bulk that's the issue. And if you
McKenna,
use a small...
I don't have to tell you where your duty lies.
We're going to take a short break and be back with more of our coverage of the Simpson trial right after this.
Showbiz Today, now at a new time, 10:30 Eastern tonight on CNN.
Judge Ito has just expressed his apologies again for the delay to the jurors who are now in the courtroom.
And I've had to make rulings on or make determinations and discuss things. And as luck would have it, it just takes a long time, some of these things. And I just want you to know that while you're back there, I'm aware that you're back in that small little room, and it's not the most comfortable place in the world. And I do have in the back of my mind constantly the pressure knowing that you're back there. But there are just some things that I have to determine out of your presence, and they got longer than I thought they would today. All right, Detective Furman, would you please resume the witness stand, please? All right, Detective Mark Furman is back on the witness stand, undergoing cross-examination by Mr. Baily. Good morning, Detective.
Good morning, Your Honor.
You're reminded you're still under oath. Mr.
Yes,
Baily, you may resume.
Detective Furman, yesterday you told us about a certain time that you were in a grand jury room with other lawyers whom you named. Have you been able to recall the identities of any of the other people that you were unable to name yesterday who were present during this exercise?
No.
Okay. And I take it you've made no inquiry as to who they were then?
No, I haven't.
Is this the only time that you were questioned in a modified court setting, so to speak?
Yes, sir.
How many other conversations did you have this year? I take it they were all this year, with Mr. Darden, Ms. Clark, Ms. Lewis, or other prosecutors about the forthcoming testimony?
Several conversations. I'd have a difficult time on numbers.
We have the same difficulty with the word several, okay? If you could use numbers, it would be much more helpful to us. Were you engaged in at least 10 different visits with the prosecution in preparation for this case, including the one in the grand jury?
I think that'd be the high number. I don't think it'd be that many. I'd feel more comfortable with maybe 8.
8 you think would be more accurate?
Yes.
And does that include this session that you described?
Yes.
Okay. Now, the subject matter of the session with the 3 lawyers was the Kathleen Bell problem, you told us.
Yes.
And that was the sole purpose of this simulated cross-examination.
To the best of my knowledge, yes.
Okay. Do you have any understanding of how the questioning that was done to you was to alleviate your concern over remarks you say you never made? What was the plan? Can you explain that to us?
No, I can't.
You can't?
No.
Well, were you told why you were being brought into that room?
to be confronted with cross-examination type questions.
All right, but I'm sure it was more explicit than that, wasn't it?
Concerning Kathleen Bell.
Concerning Kathleen Bell?
Yes.
All right. And were you told what they were hoping that you would do or not do when questions were put to you?
No.
Did any of the questions contain the name Kathleen Bell?
I don't believe so. I'm not sure on that, but I don't believe it did, no.
Did it contain the name of any other living person related to this case?
No, not that I remember, sir.
How many total questions do you say were put to you to address the Kathleen Bell problem?
Not very many. It'd be hard to estimate. It'd be also less than 10, I'm sure.
Less than 10?
Yes.
3 lawyers asked you a total of 10 questions?
There was a lot of discussion between the lawyers. It just wasn't questioning.
My question was, do you represent to this court and jury that 3 lawyers asked you a total of 10 questions in this session?
Yes.
That would be 3 and a fraction per lawyer.
Yes.
Do you know any lawyer on this earth who is capable of asking only 3 questions?
Not currently.
Touche. Detective Furman, how was it possible for these people to prepare you to confront the Bell problem, whoever brought it to your attention, myself or another lawyer, without using the words that you were claimed to have used in her presence? How did they do that?
I read some allegations. I believe it was on a declaration.
All right. Did you have in front of you a document filed in this court, signed by Kathleen Bell, alleging the conduct that we discussed before the close of court yesterday?
So are you talking about... Are you talking about what I viewed on the...
Yes.
That letter in front of me? No. I did not have that.
I'm talking about a declaration that was filed in court by Kathleen Bell as an offer of proof.
On that day?
Sustained. Nothing was filed by Kathleen Bell in this court.
I'm sorry, not by Kathleen Bell, in her behalf as to what she would say.
In front of me that day, sir?
Yeah.
No.
What paper were you looking at that was the basis of the question? Can you tell
I was
us?
looking at no paper.
I thought something was read to you or that you read that you called a declaration. Can you tell us what you meant by that?
I had read it previously. I don't know when.
Were you familiar with its contents?
I read it once, yes.
Were you familiar with the language attributed to you by Ms. Bell in that declaration?
Yes.
Was any of that language the subject matter of the questions put to you by counsel?
They did not use that language, no.
What language did they use instead to help you with the Bell problem?
They used the term racial slurs.
Okay. Well, now, do you have any memory of even one of these 10 questions?
No.
Not a single one?
No, sir.
And this happened when, Detective Furman?
I believe it was 2 or 3 weeks ago.
2 or 3 weeks ago?
Yes.
Well, now, you have been exhibiting a startling memory for detail of a crime that was 8 months ago, have you not?
Yes. Sustained.
Did any of the questions require you to say whether or not language of that sort was a part of your vocabulary?
I might have offered that.
Tell us, please, what it was you offered these lawyers in that room about your vocabulary, Detective Furman.
Did I...
Overruled.
Would you answer, please?
Yes. That I don't use any type of language to describe people of any race, such as what is alleged by Kathleen Bell.
And you never have? Is that right?
Sustained. That question's irrelevant.
Did you say to the lawyers who were trying to prepare you for the Bell problem that you never use that language?
It wasn't asked, sir.
Withdrawn. I'll be more specific. Did you tell the lawyers in that room that you never used the word nigger?
Overruled.
It was never asked.
I'm asking, do you?
Do I what?
That's vague. Rephrase the question.
Do you use the word nigger in describing people?
Presently.
Yeah.
Overruled.
No, sir.
Have you used that word in the past 10 years?
Not that I recall, no.
You mean if you called someone a nigger, you have forgotten it?
I'm not sure I can answer that question the way you phrased it, sir.
You have difficulty understanding the question. I'll rephrase it.
Yes.
I want you to assume that perhaps at some time since 1985 or 6, you addressed a member of the African American race as a nigger. Is it possible that you have forgotten that act on your part?
No, it's not possible.
Are you therefore saying that you have not used that word in the past 10 years, Detective Furman?
Yes, that's what I'm saying.
And you say on your oath that you have not addressed any black person as a nigger or spoken about black people as niggers in the past 10 years, Detective Furman?
That's what I'm saying, sir.
So that anyone who comes to this court and quotes you as using that word in dealing with African Americans would be a liar, would they not, Detective Furman?
Yes, they would.
All of them, correct?
All of them.
All right. Thank you. Did you have any other training sessions of this sort?
I'm sorry, sir?
Did you have any other training sessions of this sort?
No.
Did you have other sessions wherein the word nigger was used between you and counsel?
No.
Never?
No.
Okay. Detective Furman, I'm showing you what I believe to be a replica of the flashlight you described as having carried that night, and I wonder if you could tell me whether or not it is substantially similar, or appears to be.
Yes, it's exactly.
Appears to be marked. May this just be marked for identification or in case it's used later on.
1055.
F. Baily is showing, or will show, Detective Mark Furman a replica of the flashlight that he contends that he used. You see it there, of the flashlight that he used at the crime scene and also at O.J. Simpson's home. This is a replica of the flashlight. There was no objection by the prosecution. The judge has allowed the defense to use it in its cross-examination of Detective Mark Furman.
But would you check that and see whether or not, by rotating the head of the light near the bulb, it turns on and off and also changes its projection? Can you just point at a dark corner under the witness?
Yes, it does, sir.
Appear to function about the same way?
Yes, sir.
All right. Would you narrow the light to a spot? Okay, would you shine it on the screen? All right. Now, would that light in darkness, Detective Furman, enable you to see for a distance of 10 to 15 feet, do you think? To see an object?
I could see the object at that distance without a light. With the light, yes, it would aid me greatly.
No, in total darkness.
I wasn't in total darkness.
I understand.
Yes.
Well, I don't think you know yet what I'm talking about, which place and time. Or have you assumed that I'm talking about your visit to the north fence?
No, I'm not assuming that.
Assume it.
Assumed.
Yes. Now, my question is, when you were at the north fence and you saw the glove that you referred to, perhaps mistakenly, as them in your preliminary hearing, were you able...
Sustained. Rephrase the question.
You saw one glove there, correct?
Yes, sir.
Did you look around the area at all in any way?
What area is this, sir?
The area near the fence. The glove was almost at the fence, was it not?
No, it wasn't. It wasn't even close to the fence, sir.
What was it close to?
It was close to the sidewalk.
All right, but wasn't there some railings nearby, near
No.
Goldman's body?
Yes. By Mr. Goldman's body, but not by the glove and the hat.
Do you recall saying that leaves were cascading down over the glove, making it difficult to see?
Yes, there was a plant that had leaves that went up and then fell down a broadleaf plant, and it covered portions of it. Still visible, but it was clearly visible from the other side of the north fence.
Could you see that without the aid of a flashlight?
You could see the objects, but not as well as you could with a flashlight.
If you had shined that flashlight on that glove, the left-hand glove, would it have illuminated it better than the ambient light was doing?
Yes, sir.
Now, will you describe the terrain immediately around the crime scene? And I wish you to eliminate the sidewalk, which is a concrete or terrazzo inlay.
Are you talking?
Yes. But what do you have? Do you have grass? Do you have plants? Do you have shrubs?
Around Mr. Goldman?
No, around the area closed off by the fence being the one against which his body was kind of propped.
That's Mr. Goldman.
Yes.
Dirt, large tree by, I think, by his hip, buttocks area. Large meaning maybe 3 or 4 inches in trunk diameter.
Was there any other plant life growing in that area?
There was plant life, but I don't recall exactly where it was.
Was it similar to the plant that was partially covering the glove and the cap that we have seen in several pictures?
I don't recall, sir.
Did it stand about that high from the ground?
Indicating about,
I'm sorry, Your Honor. Yes, about 8-10 inches or more from the ground.
Which plant are you talking about?
I'm talking about plants that were growing outside the fence enclosure where the crime occurred and adjacent to it.
Overruled.
I can't remember all the small plants that were in the area, no, sir.
Okay. Well, can you tell me whether or not immediately adjacent to that fence and in the general vicinity where the cap and glove and Goldman were located, there were plants sufficiently high to conceal another object the size of the glove it had been lying there?
Objection, that's big, confusing,
Overruled.
I couldn't speculate on that, sir.
We're going to take a short break and be back with more of our coverage of the Simpson trial right after these words.
Today on Talkback Live, does America favor or fear interracial marriages? Tell us on Talkback Live, 3:30 Eastern on CNN.
The first and best.
You can see O.J. Simpson looking away while a photograph is displayed in the courtroom depicting the body of Nicole Brown Simpson at the crime scene. And that photo will not be shown to the audience.
That existed on the morning of June 13th?
No, if I could see a picture of from the north residence looking toward Mr. Goldman's body in a southerly direction, it would be easier to explain.
We are going to try and locate one, but for purposes of your present examination, can you tell me whether or not, from the position you were standing, if you looked across the walkway in a northerly direction, you could judge the height of the shrubbery that we see in the photo?
Yes, sir.
And was the shrubbery that we see in the photo substantially the same as what you saw when you arrived at 2:10 a.m.?
Yes, sir.
And would you agree that that shrubbery is fully capable of hiding small objects that might be dropped into it?
Yes, sir.
All right, thank you.
Overruled.
May I approach the witness, Your Honor?
During testimony during the break, F. Lee Baily established that Mark Furman took off his blazer after he was relieved from the case while at the crime scene. He reported that was close to 3 a.m. He went back to his car, took his blazer, deposited it there, and then waited for Detectives Lang and Van Adder to arrive at the scene.
Before explaining it, I would like you to look at this photograph and tell me, if you can, whether or not that was taken looking in a northerly direction from the walkway at the base of the stairs in the approximate position where Nicole Brown Simpson's body was after the bodies had been removed.
Yes, sir.
Okay. The area to which I was attempting to direct your attention is on the right or east side of that fence. Now, in looking at that photo, does that refresh your recollection as to whether the glove and the cap were found close to the fence?
Yes, sir. You're talking about this fence that runs north-south.
That's correct.
Yes.
Okay. And you recognize this as being the area where where Mr. Goldman's body was found when you were there?
Yes, this is the area I was referring to as somewhat cleared out.
May this be marked?
All right, People's 1050, excuse me, Defense 1057.
1057, Your Honor?
1057. Arrow on that.
I would like the arrow, Your Honor, so that I can point something out to the witness.
All right, proceed.
Detective Furman, we are now looking north inside the crime scene area after the removal of the bodies, or at least the body of Mr. Goldman, correct?
Yes, sir.
All right. And would you point out in that photo, and I'll ask Mr. Harris to put an arrow on it when you do, the area where the left-hand glove and cap were found?
Yes, sir. That's the area right there.
Okay, so that is fairly close to the fence, as I suggested, but you had in mind a different fence when you said it was not. Right?
Yes, sir. I was talking about the north fence.
The north fence?
Yes.
And we are talking now about the east fence.
Yes.
Now, what I was trying to learn is this. Number one, would the spot of your flashlight in the ambient light conditions coming from the house, I guess, you fellas hadn't artificially lighted anything when you were there with spots and floods, had you?
No, sir.
Okay, you were operating with flashlights and whatever light could be gained from the open door of the house?
Yes, sir.
All right. With the little flashlight that you have been handling, been capable of illuminating the area immediately outside the east wall of that fence, which is on our right as we look at the photograph?
Yes.
Okay. Thank you. Take it there. We neglected to print 1056 with the arrow where Mr. Harris put it next to the... I'm sorry. Mr. Harris is ahead. It is printed. May that be 1056? 156A, Your Honor.
For much of F. Baily's questioning of Detective Mark Furman yesterday, he concentrated on Mark Furman's activities at O.J. Simpson's estate on Rockingham. Now he is focusing back on the crime scene at 875 South Bundy, where the bodies were found. And through his line of questioning over the last few minutes, F. Baily is suggesting, if not implying, that if there were another glove at the scene, the other plants around that area may have been sufficient to have concealed it from view. That's why F. Baily has been focusing so much about what was visible from the north fence, what was visible with this small flashlight with which Mark Furman testified he used at the time. We're going to take a short break and be back with more of CNN's coverage of the Simpson trial right after this. Mark Furman is being questioned about prior meetings with the prosecution in this case in 1994.
No, when the DA's office wants to talk to a detective, they obviously will talk to him. There's nobody that would need to give me permission. I just say I'm going to the DA's office.
Well, who would you tell? Someone had to know where you were, didn't they?
Yes, sir.
Well, who's your boss? Detective
Ron
Phillips?
Phillips.
Okay. Did you tell Detective Phillips on those occasions when you were coming downtown to work on this case where you were going?
Yes.
Okay. And do you know if any records of any kind are kept about these visits?
Not to my knowledge.
Were the prosecutors keeping any records of your visits that you know of?
I don't know, sir.
All right. Now, do you leave it with the court that if you had a meeting with Miss Lewis in January, you are not certain of it?
That's correct.
You just don't have any memory of meeting this woman in January, the one seated at the table here to my far right.
Sustained. Rephrase the question.
Okay. Try again. Did you or did you not see Miss Lewis in January in this building?
I'd say I could have, but I couldn't tell you exactly when, so I can't say for sure.
Is she the first lawyer that you met and talked to?
After the prelim?
In 1995. We'll just leave 94 alone for now.
I don't know if she's the first, sir.
You don't know?
No.
Does anyone else come to mind as being the person who started off this whole series of interviews?
No.
Was it Mr. Darden?
No.
Was it Miss Clark?
No.
Any other lawyers not seated here today that you've worked with on this case?
No.
Mr. Hodgman?
No.
Okay. So, January, then, I take it, is a blank.
No.
May we now turn to February. Do you have any memory of coming to this building in February and meeting with someone?
Yes.
When was the first meeting in February that you can recall, Detective
I can't.
Phillips?
I can't recall when in February.
I'm not asking for a date in a minute. Can you say early, middle, late? Give us any help at all?
I'd say it would be fair to say probably early part of February and the latter part.
All right. Who was present at the meeting, the first one?
I've talked to Mr. Darden, talked to Miss Clark, I've talked to Miss Lewis.
Does that mean you cannot remember who was present at the first meeting?
That's correct.
And that was early in February, you think?
Yes.
Okay. When was the one after that?
I'm not sure, sir.
Early, middle, or late? Can you help us at least that much as to meeting number 2 in February, Detective Furman?
Sometime in the latter part of February.
All right. So you had a meeting in the early part of February, being the first one of that month, and you don't remember who was at that meeting, correct?
No.
And then you had a meeting at the latter part of February. With whom, if you recall?
I've talked to all these prosecutors that are seated before me.
All at once?
No. They work a team. I could talk to one. I could see another one the next day or the next hour.
Well, let's try and approach it another way. Of the 3 prosecutors facing you, with whom did you spend the most time talking about the case?
Probably Miss Clark.
When's the first time you can remember seeing Miss Clark in a meeting that you attended in this building? In February?
I believe in latter part of February.
Okay. Do you remember how long the meeting was?
We didn't have many meetings or discussions that lasted much longer than an hour once we got started.
You remember the day of the week that the meeting occurred?
No, I don't.
Do you have any memory of the time of day that the meeting occurred?
It would be after court or maybe an afternoon on a weekend, but I can't remember that period of time or day a week with the person.
Can't remember?
No.
Okay. When was the next February meeting you had after number 2 late in the month with Miss Clark?
Sir, I don't know.
Don't know?
No.
But Detective Furman, when I asked you if you'd had 10 meetings and you said 8 would be more like it, where did you get that number?
I just felt 10 was too many. It just felt like, I'm more comfortable with 8.
Well, did you pick 8 out of the air, or do you remember having approximately 8 meetings with prosecutors?
Sustained.
Did you have a memory when you gave us that answer of about 8 meetings with prosecutors?
Overruled.
That felt like a comfortable number, yes.
All right. Why did it feel comfortable?
Because it was more than 5 and less than 10.
So far, you've described 2. Were there any more meetings in February other than the 2 that you've described that you can recall now, Detective Furman?
I can't recall the specifics. I didn't take note of these. Many times it was inconvenient, and sometimes we got nothing accomplished because of scheduling and things going on with people's personal lives. Sometimes they were not much of meetings at all because of people's lives.
And were there some times when disagreements prevented anything from being accomplished?
I don't recall that.
Don't recall having any disagreement?
No.
All right. Now, how about March? Do you recall some meetings in March?
We have met, yes, in March.
The first one in March that you can recall, and I assume that it would have to be early or middle.
Yes, early in March.
Okay. Any idea what date?
I believe it was on I don't know the date, it would be on a weekend.
A weekend in March?
Yes.
All right. That'd be the first weekend in March if it was early in March?
Could have been.
Was it down here?
Yes.
Do you recall a Saturday or a Sunday?
I believe it was a Saturday.
And who was present?
Miss Clark.
How long did you talk?
About an hour, hour and a half.
Was anyone else present during that hour to hour and a half?
People came in and gave her messages or papers that I didn't know what she was receiving, and then they left.
All right. But were any of the other lawyers seated at this table or other lawyers working on this case outside the courtroom present during this hour to hour and a half?
Periodically, an attorney would come in and give her something. Sometimes they would stay for a moment, then they would leave.
Well, let me narrow it a little bit, Detective Furman. During this hour to hour and a half, did any lawyer connected to this case come in and participate in what you and Miss Clark were doing?
No.
All right, so that you talked together for 60 to 90 minutes about the case?
Yes, sir.
None of these people have ever had conversations with you about other matters, have they?
What are other matters?
Other than the case?
Overruled. You can answer the question.
I don't understand the question.
All right, let me rephrase it. You have told us that you spent a number of hours talking with these people, among others, about the case.
Yes.
You don't socialize with any of these lawyers, do you?
No.
Haven't seen them outside the work environment, have you?
No.
And you don't have any other cases going with them at the moment, do you?
No, sir.
Okay. So is it fair to say that all of the discussions you have had with these people in 1995 have been about the case?
No.
It's not?
No.
What other things were talked about?
Chris Dard and I talked about basketball.
Okay.
Miss Lewis talks about scuba diving.
All right. Were these dominant themes or just small talk as part of the overall conversation?
Just conversation.
All right. But the main purpose, I take it, of each encounter, even though there may have been other subjects touched upon, was the case, People against Simpson.
Yes.
And your role in that case.
Yes.
Now, the total number of meetings in March that you can recall, excluding the grand jury session.
2 or 3.
All right. The first was with Miss Clark for 60 to 90 minutes. When was the one that you meant when you said 2?
I believe that was during the weekday after court with Miss Clark.
And when was that?
I believe the following week.
So if you met on a Saturday, then some day during the following week after court had adjourned. I take it was late in the day.
I believe so, sir.
And how long did that session last?
I recall it was about an hour.
And were any other lawyers involved to the extent of participating in that conversation that you were having?
I think periodically Miss Lewis came in and out.
Did she stay long enough to position herself in the conversation or just drop something and take off?
Well, a lot of times when another person comes into the room, Miss Clark will stop, take care of business, or wait till they leave, and then we continue.
All right. My question to you was Miss Lewis assisting Miss Clark in some way in the preparation for this case, or simply coming in and out on other matters other than the Furman testimony?
No. Okay. Miss Clark dealt with me directly.
And you said 2 or 3. If there was a third, what's your recollection as to that?
Close to the beginning of my testimony, or close to that week.
Your testimony began, I believe, last Thursday.
Yes, sir.
So how long prior to that was your meeting with Miss Clark, if it occurred? I'm now looking for a third one.
Yes, that was very brief.
Yes. How long prior to the onset of your testimony did it occur?
2-3 days.
Not the day before?
I don't believe so, no.
You weren't in the building the day before?
I was in the building the day before, yes.
What were you doing?
Waiting to testify.
Not talking with anyone?
No.
Okay. Was your lawyer with you at the time?
No, he was watching the TV and I was not.
Now, have you spent any time with him, without going into anything that was said, preparing for your testimony in this case?
Preparing for direct testimony in this case?
No. Preparing for the cross-examination you assumed would follow hard on the heels of direct.
I think I've gotten some general advice, much the same as I've gotten from most of the people I know.
Okay. And you have been urged to remain calm, have you not?
I'm going to sustain the court's own objection in the context of the previous...
I'm sorry. I mean to exclude Mr. Tortolo from any question that has substance of a conversation in it. I do not ask to go into anything he said to you. But you mentioned that you had advice from a lot of people, and what I meant to ask you was, did a lot of people say it was very important to remain calm?
Oh, no.
No. Were any documents, books, or other materials given to you or exhibited to you at any of these sessions to assist you in your role as a witness in this case?
No.
You have read no books on how to be a good witness?
No.
None on cross-examination?
None.
Have you watched any films or tapes that relate to that subject?
None.
And have you discussed your position with fellow officers and sought their advice as to how to be an effective witness?
No.
Now, Detective Furman, is it not fair to say that in your 19-year career, this is by far the most important case in which you've been involved?
Yes.
Is it not also true that you realize now, as you did back on June 13th, that the right-hand leather glove, which you claim to have found in Rockingham, could be a very significant piece of evidence in this case?
Yes, sir.
And are you aware of the fact that your testimony, as it pertains to that evidence, may be very, very important to this court?
Yes.
Did you anticipate, based on what you had been told, that some sort of attack might be visited upon you with respect to alleged racial slurs?
No.
Was it a surprise to you when those questions were put by Marcia Clark at the very outset of your testimony to give you a chance to deny the allegations before I have talked to them? Withdraw the question. Do you recall that when you took the stand, you explained to the jury and to the court that you had had some special sessions because of a problem not related to the facts of the case?
Overruled.
You recall that?
Yes.
All right. Do you recall that Ms. Clark then caused to be displayed to you parts of a letter allegedly written by Kathleen Bell to Johnny Cochran and invited you to examine the text of that letter? Do you remember that?
Yes, sir.
Okay. Had you discussed the fact that this was going to happen before you ever came into the courtroom?
Yes, that part, yes.
This was no surprise to you, was it?
No, sir.
And were you not advised that the effort in doing so was to steal the thunder from the inevitable cross-examination?
Sustained.
Was it explained to you that this was an effort to defuse the impact of any accusations that might later be made against you?
Sustained.
Why, if there was an explanation, was it explained to you that this method of introducing your testimony was to be used in this case?
It wasn't explained to me, no.
Well, in other words, as I understand it, you were simply told, here's what we're going to do, Detective Furman. Here's the order in which things will happen when you hit the witness stand, and we're not going to tell you why.
I'm not the prosecutor, sir.
I know that you're not the prosecutor, you're the witness. Did you have any comprehension as to why this tack was taken by the prosecution?
Yes.
Did you understand that it related to possible experiences you might have on cross-examination?
No.
Okay. What was your understanding as to why this letter was surfaced at the outset of your testimony?
I think his frame of mind is relevant. Overruled. His understanding. His understanding. No, I've inquired, counsel. It is relevant, his frame of mind. Overruled.
Give us your understanding of why this was done in this case.
Because that's why Ms. Clark, the way she wanted to litigate this case.
Okay. And beyond that, you had no comprehension as to why it was done. Is that right?
No.
Did you not testify at the very outset of your testimony that you have been subjected since the preliminary hearing to a barrage of personal attacks which made you nervous as you first sat down in the stand?
Sustained.
Did you tell us something about your experience since July 6th, or a little later, perhaps around the 14th, that was unusual?
No.
Did you tell us anything about problems you had had that were specific to this case and no other and did not relate to the evidence in the case?
Yes.
What did you mean to convey when you told that to this jury? What were you thinking of when you talked about these problems?
Being accused of committing a felony and a capital crime.
Okay. Was that the only accusation that was troubling you as you took the witness stand?
That's the only one I care about, yes.
The other ones, the accusations that you use racial epithets you don't care about at all, is that correct?
I didn't say them. I don't care about them.
You don't care about them?
I didn't say them, sir.
Oh.
Witness answered.
Yeah. Did you read, without specifying the publication, in one of the media covering this case, a printed article, that disclosed or purported to disclose that you were undergoing some heavy training in the DA's office? Did you?
Sustained. Rephrase the question.
I'm sorry, Henry?
Rephrase the question.
Okay.
We're going to take one more short break and be right back with more of the cross-examination of Detective Mark Furman.
Bill's such an active guy. I sure didn't expect to hear him talking about retirement.
Yep. Every year like clockwork, straight in the IRA.
Bill, you're never going to retire. You're going to run forever.
Well, who said anything about retiring? That's the time for me to do what I want.
That's going to take financial independence.
That's the plan.
Whatever your retirement goals, the key to achieving them is to have a plan. Fidelity Investments can help you get there.
We saved and saved to move into a new house. But as I finished our change of address cards, I saw we have to pay more attention to the most important savings of all.
My IRA statement. Look at that.
Oh, boy.
We gotta do better than this.
Ooh, I agree. We got to move this, too.
Fidelity offers a wide range of mutual funds for your retirement savings. And now, for Fidelity retirement investors, we've waived the sales charges on a dozen of our stock mutual funds. So call Fidelity today for a free IRA fact kit, including Fidelity's retirement planning guide. Call 1-800-372-5959.
It was 1 a.m. I'm hurting. I can't sleep. And I'm worried about taking something. Is it okay?
F. Lee Baily is once again focusing on Mark Furman's so-called practice session with prosecutors in the grand jury room and an article relating to that practice session.
Now, do you remember, do you know when Newsweek comes out and when it's generally distributed in this area?
I believe it's Sunday or Monday.
Well, if you're connected Sunday night and on the newsstand sometimes Monday, is that your experience?
I don't go to the newsstands and buy it, so.
Okay. Do you read Newsweek?
Sometimes, but not usually.
Well, assuming that sometime on the Monday, sometime after the grand jury preparation, Newsweek came out, was Miss Clark the first one to bring to your attention the content of the article?
I'm not sure. I believe so.
Mr. Tortolo didn't call you up and tell you what was being published about
I
it?
sustain the court's own objection to that question, counsel.
And Mr. Pelicano?
Same objection. Investigator employed by an attorney.
Okay. All right. Let me put it this way. Did anyone, other than your lawyers, in private conversation and prior to Miss Clark, bring to your attention the existence of this article?
Overruled.
I don't believe so.
All right. When you walked into her office and she told you about the article, was she holding the magazine, if you remember?
I don't.
Do you remember what she said that enlightened you as to what had happened in the magazine?
No, sir.
Did you at some point during the conversation come to understand that Newsweek was describing, more or less, the grand jury case preparation that you had experienced?
I believe that was the description I assumed, yes.
All right. Were you questioned as to whether or not you had told anyone about that in the media?
No.
Was there any conversation between you, Miss Clark, and possibly others on that day about how the media had gotten hold of it?
I think there was a...
Sustained.
Okay. Subsequent to this conversation with Miss Clark, did you have a conversation with her or any of the prosecutors about bringing out the grand jury preparation session early in your direct examination?
I don't believe we did, no.
Well, I said subsequent now. That means up to today. You had an experience with Miss Clark in the office where you learned about Newsweek.
Yes.
You've told us that you were not surprised when she developed early in your direct examination that you had undergone a practice cross-examination with some lawyers. If you were not surprised, at some point, I take it, you were informed that that was going to happen.
Yes.
Okay. Were you informed that that was going to happen sometime after the Newsweek article came out and you two discussed it?
No, I think Miss Clark told me that she was going to bring that up on direct, and that was as far as it went.
No. When did she tell you that?
Right before I testified.
Just before you testified?
No, the day before, maybe a day and a half.
Prior to that, you'd never heard of that plan, had you? Isn't that true?
Overruled. All right, with the court report, please.
I withdraw the question.
Easier.
You just said that Ms. Clark explained to you a day or two before your testimony that she would elicit from you the fact that you had practiced cross-examination, correct?
I don't know if it was exactly those words, but yes.
To that effect?
Yes, sir.
Was this a day or two before your testimony the first time that this idea of bringing this out was conveyed to you?
Yes.
All right. But at no time after the experience took place and prior to the publication of the Newsweek article were you told that any such disclosure would be made. Isn't that so, Detective Furman?
Objection, Your Honor. It's exactly the point. I'd like to approach.
All right, with the court reporter, please.
I do not withdraw this time.
All right.
While the attorneys go to sidebar, let's bring in our legal analyst. First, Greta Van Susteren, what do you make of F. Lee Baily's approach today? It seems to be a scattered approach, going back and forth in both time and place. Do you think this is deliberate?
Jim, I think this may be a sample of a little disorganization. We've already gone over much of this information. Now, the business about Newsweek is perhaps new, but that could have been brought out the first time he went over the subject of witness preparation. And remember, he's got a jury there, and he's got to keep them interested in what's going on. And if he keeps grinding and grinding over the same topics, he may lose the interest of the jurors, and that interest may later lead to annoyance with him. He needs to make his points and sit down.
Stan Goldman, do you think this is more strategy than disorganization on F. Lee Baily's part?
Yes, I agree that it is rather dull, and I may be giving him more credit than he deserves, but I really do think this is planned. I think he's got a tactic in this case, in terms of cross-examination, of bouncing back and forth between topics, hoping he can catch the witness in either a misstatement or get the witness to reveal something he wouldn't have revealed had we been going through this progressively one step at a time, covering an area completely and then moving on to a different area.
Before the jury was brought in, there was more than an hour and a half of heated argument between the attorneys on both sides, and Marcia Clark essentially contended that F. Lee Baily may be lying to the judge. Let's listen to a portion of that exchange.
Tell us, please, what it was you offered these lawyers in that room about your vocabulary, Detective Furman.
That
Would you answer?
Yes. That I don't use any type of language to describe people of any race, such as what is alleged by Kevin.
We apologize. The portion of testimony being shown was actually before the jury, and that is where F. Lee Baily asked Mark Furman point blank about whether he used racial slurs. Let's listen to that now once again.
Ms. Clark, let's assume, for the sake of the argument, that what you say is correct, that this misrepresentation has been made to the court. What action or sanction do you seek as a result?
I think that the witness should be precluded from testifying. I think that Mr. Baily should be cited for contempt and fined substantially. As an officer, as officer of the court, he has lied to this court. He is impeached by his own witness.
I ask that you put a stop to it. Either put Cordoba on the stand
Excuse me, Mr.
or
Baily.
stop her from testifying.
Stand up and speak when it's your turn.
Mr. Baily, do not interrupt counsel. I understand this is a volatile issue, but it's a big problem for the court. I'd ask you to control yourself, sir. Ms. Clark.
I think that what has occurred is very serious. And I think that the interview with Mr. Cordoba makes it's very stark. There are no gray areas here. This is not a matter of hair splitting anymore, as Mr. Baily got up to represent to the court this morning. Mr. Cordoba was confronted with the statement that Mr. Baily made, that they spoke. He said, no, we did not, and I would remember. And there was the opportunity to say we had some conversation, and he did not do so.
That was obviously the heated exchange outside the presence of the jurors. You can see the attorneys are still in sidebar. The judge has ruled that the defense must postpone the cross-examination of Mark Furman on this so-called Max Cordoba issue until the defense case has begun, and they are not allowed to cross-examine the witness about another witness. Let's listen into the proceedings.
All right, thank you, counsel. And Mr. Baily, this will be the last question before the noon break. I have a meeting.
Yes, Your Honor. Detective Furman, between the time that you did grand jury case preparation on the weekend and the time that Ms. Clark brought to your attention the contents of the Newsweek article describing that event, did any prosecutor tell you between those two events we're going to bring the preparation session out early in your testimony?
No.
I didn't hear the answer.
Wait, there's an objection. All right, overruled.
No.
Thank you.
All right, ladies and gentlemen, we're going to take our recess for the morning session. Please remember my admonitions to you. Don't discuss the case amongst yourselves, form any opinions about the case, allow anybody to communicate with you, or perform any deliberations till the matter has been submitted to you. We'll stand in recess until 1:30. Detective Furman, you're excused until 1:30.
Yes, Your Honor.
All right. As the court adjourns for lunch, let me bring you up to date on another matter in the Simpson trial. A defense source tells CNN's Mark Watts that another Simpson juror could be lost soon in this case. That would be the 5th juror released since the trial began. The juror, according to the source, tells Mark Watts it is a 52-year-old male of mixed race, Native American and Caucasian. Attorneys on both sides, apparently, according to our source, do not like the juror. He exhibits what has been characterized as odd behavior and does not interact or speak much with the other jurors, according to the defense source. That is an issue still yet to be taken up with the court. A transcript of a sidebar released for yesterday's sidebar says that they may take that issue up today. However, it was unclear in the transcript. Again, our live coverage of the Simpson trial will resume when court is once again in session. That's at 4:30 p.m. Eastern, 1:30 Pacific. I'm Jim Moret in Los Angeles. Now we'll go to Atlanta for a news update with Lou Waters. Court is once again in session. We can see that the attorneys are present. There's Mark Furman, who's about to retake the witness stand for his 5th day on the stand, actually, 3rd day of cross-examination. And what the attorneys are discussing right now is a letter prepared by Mark Furman's attorney. And the issue is the copy, the photocopy that the judge has and that the attorneys have is unclear as to the amount of money that was expended on behalf of Mark Furman by his attorney. Let's listen into the proceedings.
All right, we're
doing it now.
All right. Are we ready to proceed in the absence of that? I'd like to see the read and a clear copy of this letter before we proceed with it.
The court has not issued a ruling then.
No, one of the critical lines here is obscured to me. And I assume your copy is the same.
Yes.
All right. All right, then let's get as far as we can with the jury this afternoon. All right, Deputy McNair, let's have the jurors, please.
As the jurors come in, let's go to CNN's Art Harris, who spent the morning in the courtroom, and most of this morning's fireworks were out of the presence of the jury. Art, how is the jury reacting to the long and rather laborious cross-examination of this detective?
Jim, they're paying very close attention. They're rapt. They're leaning forward in their seat. Most of them have notepads and pens, taking notes. It's almost as if they're watching a prize fight. They were especially riveted when F. Lee Baily asked Mark Furman if he'd ever used the N-word. It was as if they were leaning forward, watching, studying Furman to see if there were any signs that this was a racist cop, as the defense has alleged.
I know you had an exclusive interview over the lunch hour with Chris Darden, one of the prosecutors. What can you share with us?
Well, Chris Darden was very upbeat. He was carrying a bouquet of flowers from one of his many fans. One of the nicknames he's going by these days is Prosecutee. But he talked a little bit about how he felt Furman was doing. He said they were very pleased that he was maintaining his composure on the stand. And there's even discussion that he's doing so well that they are considering not even doing redirect. He's not sure yet, but he said the only person today who used the N-word in court was F. Lee Baily, not Mark Furman, and he felt that that had made an impression on the jury.
Thank you. That's CNN's Art Harris live at the courthouse, and you can see that Mark Furman is once again retaking the witness stand for the continuation of cross-examination by defense attorney F. Lee Baily.
Detective Mark Furman is again on the witness stand, undergoing cross-examination by Mr. Baily. Good afternoon, Detective.
Good afternoon, Your Honor.
You're reminded you're still under oath. Mr. Baily, you may continue.
Thank you, Your Honor. Detective Furman, yesterday when you were quizzed about the contents of the homicide kit in the vehicle that you and Detective Phillips picked up, one of the items that you mentioned that was carried in these kits was plastic bags.
Yes, sir.
Were there any of roughly this type of commercial Ziploc sandwich bag, size and type of plastic in the homicide kit?
No, we don't have any Ziploc bags.
You don't?
No, we have I'm sorry.
Tell me what you do have.
A jail bag, what you put an arrestee's property in. Then it's heat sealed with a heat seal that's kept in the jail.
Okay. And I believe you said something about different size bags. Is that true?
Well, the jail bags are one size that I know is in there, and then you might have very small ones used for narcotics.
Okay.
All right, let the record reflect what Mr. Baily has shown to the witness is a sandwich-size Ziploc bag.
Roughly 6 by 7.5 inches, Your Honor?
Yes.
Okay. All right. In other words, plastic bags of various sizes are available for the collection of evidence?
Two that comes to my immediate memory, yes.
Okay. And you mentioned also that rubber gloves are available?
Yes, sir.
Okay. Now, once again, Detective Furman, have you attempted to find out the identities of the people you were unable to name who were in the grand jury case preparation exercise?
No.
Does the name Melissa Becker mean anything to you?
None at all.
Do you remember any law students being present during that time? Anyone identified you as a law student?
I do not know any of the people in the room.
Sorry. Melissa Decker.
No, I still don't.
Okay. And you don't know whether any of the people in the room were law students?
I don't know what their status was, no.
Is there anyone in this room other than the lawyers seated at counsel table who were present during that exercise?
Overruled. Oh, I'm sorry. Stand corrected. Sustained. It does. Rephrase the question.
Yes. Do you see anyone in the courtroom who was present that day other than these lawyers?
I'd say objection.
Direct your attention over this area, Detective Furman.
Your Honor, same objection. Seems facts not evidence in the state testimony. Assumes that all of us are present.
No, that's not my understanding of the question. Other than these lawyers.
Other than these, it assumes these lawyers were present.
Other than these lawyers here in the courtroom is the way I... Why don't you rephrase the question so it's crystal clear?
You told us Mr. Darden and Ms. Lewis were present.
Yes, sir.
Mr. Clark was not. Miss Clark was not, I take it.
She was not.
All right. Do you see anyone other than the lawyers? 1, 2, White, and one other that you named, assistant district attorneys, in this courtroom who was present during that session?
I don't believe so.
Looking in the audience, you don't recognize anyone who was present?
No.
Okay. You mentioned a Mr. Runyon. What does he do?
I believe I see him assisting Mr. Darden.
Okay. Have you had any contacts with or interviews with, since the 1st of January, any psychologists? In connection with the testimony?
No.
None at all?
No.
Have you received any counseling from anyone other than lawyers with respect to your testimony?
No.
Okay. The name, Detective Furman, Don Vinson, mean anything to you?
Don Vincent, I believe, is a city attorney.
Do you know any other Don Vinson or know of one?
No, sir.
Okay, and how about Mark Goldston? That name mean anything to you?
The name Goldstein does not know.
Have you had any contact with anyone by either of those names in connection with this case since the 1st of the year?
Not to my knowledge, no.
Okay, thank you. Now, in your direct testimony, you explained to us that at the request of Detective Van Adder, I believe it was, you and Detective Phillips went back to Bundy to review the left-hand glove that you had seen there.
Yes, sir.
And the purpose of that was for you together to make a judgment of some sorts as to the probability that the two gloves were related, the right hand at Rockingham, the left hand at Bundy.
Yes, and to see if they were similar.
Okay. And in connection with that effort, I believe you said that you took a pencil and picked up, or pen, and picked up the glove to see what the lining looked like.
Yes, lifted it up, yes.
Can you explain to me in a little more detail, and you can show us if you wish with this glove, how you picked it up? In other words, where the pencil was put?
I didn't pick it up, sir.
Well, did you lift it at all, or just lift one
Just
flap?
lifted it, yes.
Okay. And how far did you lift it?
A couple inches.
And did you shine your little light on it? Was it light enough so you didn't need to by the time you got back to Bundy?
I was looking predominantly at if it was a right or a left, and the lining, color of the leather.
And you found that they were similar?
Yes.
And then you went back and made your report?
Yes.
Now, you remained at Rockingham for some time after that, did you not?
Yes, sir.
You know a witness in this case named Ron Shipp?
Yes.
Did he talk to you on the phone that morning?
He did.
Okay. And prior to talking to Ron Shipp, did you make an effort to find out whether anyone in the neighborhood had heard anything unusual that night?
No.
Did you go question anyone in the neighborhood?
No.
Did you go to any home in the neighborhood?
Yes.
Whose home?
The house to the north that I now know is the Salinger residence.
All right. And did you encounter someone there that you were able to talk to?
Briefly, yes.
And was that Rosa Lopez?
I have no idea.
You didn't get her name?
No.
You didn't write it down?
No.
Did you ask her if she'd heard anything unusual? Just yes or no?
No.
What did you ask her, if you remember?
If I could look down the north border of the residence, something happened next door, and I just wanted to look and see if there was anything on their side of the property. They said no problem.
All right. Now, did you make any inquiry as to where her bedroom was, if she had one, with respect to the Simpson house?
Absolutely none, sir.
Did you make any inquiry as to whether or not she had seen anything that night over at the Simpson house?
No, I didn't.
Did you inquire as to whether or not she had heard anything that night at the Simpson house?
No.
By this time in your investigation, having in mind the blood that you discovered on the Bronco and the glove that you discovered in the alleyway, had Mr. Simpson become a suspect in your mind as a detective?
I think there was a remote possibility, but nothing was solid, no.
A remote possibility?
Yes.
Okay. Well, were you present when he arrived from Chicago and they slapped handcuffs on him? Oh, well.
Yes.
Well, when you slap handcuffs on someone, you're taking him into custody, aren't you?
Not always, no.
Oh, you have the right to handcuff a citizen without a criminal charge?
There are instances you could, yes.
Have you done that in the past? Handcuff people against whom there was no charge?
Oh, well. There's times when people pick people out as suspects and you later identify that they were not the suspect and you would release them.
But that wasn't the case here, was it?
I don't know what the case as far as he was handcuffed. I did not order that.
Without going into the details, had you had conversation with the other detectives as to whether or not Orenthal James Simpson was a suspect in the double homicide on Bundy?
No.
That had not ever been discussed prior to your going to the house next door. Is that correct?
That's correct.
Had it ever passed your mind, however remotely, that that might be the case?
Not knowing his whereabouts the night before, I felt it was extremely remote.
Not knowing his whereabouts?
I knew he was in Chicago.
Well, you also knew he didn't leave till 11, right?
I didn't know that, no.
You didn't think the limousine was there to pick up anyone else at 11 o'clock, did you?
I didn't know about the limousine other than what Cato initially told me.
How much more do you need to know? He saw a limousine at 11 o'clock. Withdraw the question. Did that seem significant to you with respect to the whereabouts of the rather famous owner of the house, that there was a limousine there at 11 o'clock.
Sustained.
Did Cato Kalin tell you that he saw a limousine there at 11 o'clock when he went outside after he heard the noise?
Yes.
Okay. Now, my question is, did that in any way relate to the possible presence or absence of Mr. Simpson at about that time at his home?
I had no idea.
Did you think maybe the limousine was bringing him back from somewhere?
I did not give it any thought.
Well, you knew he had gone to Chicago, didn't you?
Yes, I had been told that by then.
You knew that Detective Phillips talked to him in Chicago, didn't you?
Yes.
The next morning.
Well, I take it we're still in the context of when Detective Furman went next door to the Salingers.
Trying to find out what he then knew.
All right.
Okay. You knew that he reached him in Chicago by telephone, didn't you?
Yes.
Okay. And that Detective Phillips was satisfied that the recipient of the call was in fact in Chicago, correct?
Yes.
All right. So at some point he had traveled to Chicago. Did that occur to you?
Of course.
All right. Did a question arise in your mind as to when he might have traveled to Chicago?
It did not.
Well, did it occur to you if he traveled to Chicago before the ice cream was purchased, at which point the victim, Nicole Brown Simpson, was very much alive, that he would be eliminated as a suspect insofar as direct participation in the homicide was concerned?
I never gave any of that.
I'm sorry. Ms. Clark? Calls for a conclusion as well. Sustained.
Were you, Detective Furman, during the course of your stay from 2:10 a.m. until you talked to Ship, let's say around 10, is that correct? 10 o'clock?
I don't recall what time he called.
Mid-morning?
I believe so.
All right. Were you engaged in your profession as a detective of the Los Angeles Police Department?
At the time I talked to Mr. Ship?
No, sir. From 2:10 a.m., when you arrived on the scene, until at least mid-morning on the 13th, were you engaged in your profession as a police officer?
Yes, sir.
Were you being paid to carry out the function of a detective during that period?
Yes.
Were you giving that your best effort during that period?
I was being directed. Yes.
You were being directed?
Yes.
You weren't directed to the Bronco, were you?
No.
You weren't directed to the south border of the Simpson property, were you?
Yes.
By whom?
Mr. Kalin.
Mr. Kalin ordered you to go out and look for where the noise came from, detective?
No, he directed me by his statement.
Does he have the power to direct any detective in the Los Angeles Police Department, Detective Furman?
Direction and the logical thing to do would be one and the same.
They're one and the same. Do
Yes.
you want to leave it that Cato Kalin directed you to go out and look for the noise or its source?
By his statement? Absolutely.
Okay. You had no choice but to do that without telling anybody, correct?
I had a choice. That was the logical thing to do.
All right. Well, let's continue. When you learned that Mr. Simpson was in Chicago, did it occur to you that the presence of the limousine might be of some significance?
I did not give the limousine any thought after that.
Did you give any thought to the possibility that Mr. Simpson was or was not in Brentwood between 9 and midnight?
No.
That never crossed your mind?
Well, it was out of my realm of responsibility at that time.
Well, you claim that you found an instrumentality of murder, what turns out to be on his property. Did that give you any cause to suspect Mr. Simpson?
Knowing he was in Chicago, I think it would be quite the opposite.
All right. Well, now, you attached some significance, as I understand it, to the Bronco, initially against the possibility that people inside would be injured, correct?
Yes.
All right. You had ascertained by questioning Cato Kalin that only O.J. Simpson drove the Bronco, correct?
Yes.
And you had noticed a shovel and some plastic, which you did not then understand, in the back of the Bronco, correct?
Yes, sir.
All right. And you have before cited this set of circumstances as being relevant to the pressing need to go over the fence onto the property, correct?
Yes, sir.
All right. Were they also relevant to the possibility that Mr. Simpson should be looked at as a suspect on the 13th of June?
Not at the time as you are describing these, no.
Okay. When you learned that he was the only driver of the suspect, of the Bronco, according to Mr. Kalin, were you interested to know whether the Bronco might have left the premises that night during the period during which the murder may have occurred?
That would have been helpful, yes.
It would have been helpful. Oh, no. When you spoke to Miss Lopez to get permission to go back along the borderline and wherever it was you wanted to go on the Salinger's property, did you ask her any questions whatsoever about the Bronco?
No.
Or any questions whatsoever about the doings at the Simpson place the night before?
No.
Okay. Did you then go and make an inquiry or investigation of the terrain to the south side of the Salinger property, along the fence?
Yes, sir.
By the way, did you ever identify yourself to Rosa Lopez?
Yes, sir.
As Detective Furman?
Yes.
Okay. Did you take any notes when you talked to her?
No.
Or make any later on of the conversation?
No.
And did you ever say to her that you would have some other officers get in touch with her?
No.
So as far as you were concerned, there was no point in you or anyone else questioning Rosa Lopez?
There was nothing she indicated that should be interviewed for, no.
Well, you never asked her a question. How could she indicate anything?
As far as I'm concerned.
Do you determine without asking questions whether witnesses have information?
No, sir, you misstated. I wouldn't have interviewed her.
We're going to take a break in the cross-examination of Detective Mark Furman and be back with more right after this. Baily is focusing on Detective Furman's search of the neighbor of O.J. Simpson, identified as the Salinger home where Rosa Lopez worked the morning of June 13th.
Which had no image at that point, Spanish or Hispanic.
I don't recall that there was a heavy accent, no.
Do you recall any accent that would tend to identify the speaker as someone born in another country?
It's a possibility, but I don't recall it.
Okay. And when was the first time you ever spoke to anybody about this encounter with the person at the Salinger?
I believe when Rosa Lopez came forward as a witness.
Well, you mean when she was first listed by the defense a long time ago or recently?
I'm not sure on that, sir. I don't know when she was listed, and I don't know when she testified exactly, so I would probably say sometime in between there.
Did you ever learn, as a result of any hearings before this court, without going into what was said, that it was alleged that you had talked with Miss Lopez the morning of the investigation, the first morning?
Yes, I heard that.
Do you remember when you first learned that?
No.
Have you ever made any effort since that time to get a look at Miss Lopez to see whether or not, or listen to Miss Lopez to see whether or not you could recognize that person as the one you may have talked to on the morning of the 13th?
Yes, I saw her on the news.
All right. And did you listen to her?
Yes.
Did that help you in any way as to whether or not this is the person you questioned on the morning of the 13th?
Oh, she was speaking Spanish, so no.
All right. You did not hear her speak English?
No, sir.
Did not hear her here on the witness stand testifying?
No, I saw a clip on the news. I believe it was of her testimony.
Okay. All right. And to this day, by the way, do you know what, if any, portion of the neighborhood around the Simpson home was searched for these items of evidence that you and I have been discussing, such as weapons and clothing?
No, sir.
You never participated in, gave any direction to other officers about, or otherwise involved yourself in a search for items of evidence of this sort?
I was there during the search warrant, and I assisted in the closet of Mr. Simpson's bedroom and some of the exterior portions, but that's it.
Who was the first person, if you know, by the way, ever to go up to Mr. Simpson's bedroom after you entered the premises?
I don't know, sir.
What time did you go there first?
Inside the residence?
Yes.
With Mr. Kalin.
How great an area, if you know, around Bundy was searched for bloody clothing, other accoutrements might have been worn or used by the murderer, including a weapon?
I have no knowledge of that, sir.
Didn't Officer Risky tell you where he had caused people to look for items of that sort?
I don't recall that, no.
All right. Did you continue working on this case after June 13th?
I believe I was asked to do a few things. Yes.
Did you know that Detective Van Adder said on June 6th in his sworn testimony that you were still very much a part of the case as a detective?
Well, I think that would include the times that they ask us to do certain things, yes.
All right. And when did you last do any work on this case, Detective Furman? Other than prepare yourself as a witness?
It would have been last year, sir.
I understand.
Maybe a month after the crime.
You think you may have continued through July to work on the case?
Yes, there might have been some things I did, yes.
And some part of August you may have worked on the case?
I'm not sure, sir.
All right, well, assuming that jury selection or proceedings pointed toward jury selection began September 19th of 1994, did you do any work on the case after that?
I can't remember, sir.
You don't know whether you've done anything on the case since this proceeding began?
I don't believe I have, no.
Did you receive an instruction of some sort, Detective Furman, to abstain from viewing these proceedings?
Yes.
And have you followed that instruction?
Yes, sir.
Now, over the lunch hour, did you have any chance to reflect or have your memory assisted by any of the minions for the prosecution as to the sessions that occurred before the trial, your part of this trial, and since the first of the year?
No.
Would you say, Detective Furman, that in addition to this being the largest case in which you've ever been involved, this is perhaps the most important testimony in which you've ever been involved?
Sustained.
Have you not been very concerned since January 1 and beyond with the experience of testifying in this case?
I believe I was concerned with the allegations that have been brought forth against me.
Yes.
Yes.
You were concerned with something happening which has now happened, correct?
No, objection.
Sustained.
Withdrawn. Having that in mind, Detective Furman, were you anxious that you deliver a good performance on the witness stand?
Overruled. Overruled.
I'm always concerned with that in every case.
In this case more than others, Detective Furman?
I am testifying just like I do in any other case.
Mm-hmm. And have you ever in any other case faced accusations such as you expected in this case?
Sustained.
Have you ever in any other case had the benefit, may I finish the question, have you ever in any other case had the benefit of a grand jury case preparation session such as you had here?
Overruled. Denied. You can answer the question.
No.
I thought we already asked that once before.
Okay. Now, having in mind all of that, do you maintain that you have almost no recollection of the sessions intended to prepare you for this testimony?
That's correct, sir.
Overruled.
Have we solved the earlier problem, Your Honor? Described it.
Nothing has been submitted to me.
Well, I understood that it was coming forth with. Have we learned the status of that, perhaps?
Ms. Lewis?
We're going to take a short break in the testimony of Detective Mark Furman and be back with more of CNN's coverage of the Simpson trial right after this. While we were in the break, there was a short sidebar conference, and the judge has just told the jury to take 5 minutes as a recess so they can get another document together for the conclusion of the cross-examination. Just prior to the break, the last questions F. Lee Baily asked of this witness were, upon your arrival at the Ashford Gate at O.J. Simpson's estate and discovering the blood on the Bronco, weren't you concerned someone might be bleeding to death inside Simpson's estate, including O.J. Simpson? The response was yes. However, it was then pointed out on testimony that at the time they entered the house, the detectives, or Mark Furman, never asked anyone where O.J. Simpson was. Let's go to Greta Van Susteren, our legal analyst in Washington, D.C., for your comments on this afternoon session of the cross-examination.
Well, Jim, that is a very good point for the defense to make because it tends to undermine the credibility of this witness. If he were worried about whether or not O.J. Simpson were bleeding to death, of course, that would be the important thing to find out once inside. Where's O.J. Simpson? The other interesting part of the cross-examination this afternoon is that F. Lee Baily very effectively corroborated Rosa Lopez's allegation that she spoke with Mark Furman. And what the defense is trying to do is corroborate its own witnesses, should the defense decide to actually put on that videotape. But they tend to corroborate by asking questions of Mr. Furman.
Here in Los Angeles, Stan Goldman, a professor of law at Loyola University, Loyola Law School. Professor Goldman, one of the lines of questioning, having in mind the blood you discovered on the Bronco and the glove that you discovered at Simpson's estate, was Simpson a suspect? Mark Furman says it was a remote possibility. Is that a believable answer?
Well, I think that was one of the real scores by the defense this afternoon. I think when the next morning already, hours have passed. They've discovered the blood on O.J. Simpson's Bronco. They've discovered a bloody glove on his property. This is the detective who investigated O.J. Simpson a few years before for abusing his wife. Take all those things together, and the next morning he still only thinks it's a remote possibility that O.J. Simpson may have been involved. I think a lot of jurors are probably thinking about, wait a minute, is that accurate? Could he possibly not have suspected O.J. at that point? And if we suspect that this officer is not telling the truth about that, what else might the jurors decide he might be fabricating?
Greta, what's your response to that line of questioning? Did it seem surprising to you that this witness, Detective Furman, would say that even after finding the glove, after seeing the blood, after scaling the wall, doing various questioning of Arnell and Cato Kalin, that in his words, it was a remote possibility that O.J. Simpson was a suspect in this crime?
Jim, I've never bought from the very beginning that those police officers didn't think when they vaulted that wall that O.J. Simpson could be a suspect. I mean, police officers are in the business of searching for criminals. Everybody's a suspect. And when you have two dead bodies, everybody who comes in contact with the bodies or anyone who remotely knows them is a suspect. And I think perhaps the jurors were not quite impressed with Mr. Furman on this testimony. I agree with Stan. I think this detective clearly thought O.J. Simpson was a suspect, and I don't think the jurors bought that he wasn't.
Earlier, before the jury was present this morning, in the morning session, there was approximately 1.5 to 2 hours of argument, part of it dealing with one of the witnesses the defense wished to call a Max Cordoba. Now, Judge Lance Ito handed the defense 2 blows, making the scope of Mark Furman's cross-examination that much smaller. Judge Ito ruled that the defense cannot cross-examine Furman about Cordoba's supposed allegations until the defense begins its case. A red-faced and obviously upset F. Lee Baily jumped up to object, but to no avail. Ito also ruled that the defense may not cross-examine Furman about a woman the defense claims also can corroborate that Furman is a racist. Now, Baily was down but not out for the count. He had another prop to pull out, a glove. Baily wanted to use a substitute glove in a plastic bag to try to show how Furman could have carried it to Simpson's estate and then planted it there. An objection from Clark and a retort from Baily.
This has no part in any search for the truth. This is a fantasy woven by the defense, for which there's no evidentiary basis, no logical or factual connection to this case.
Let me ask you this. What is the glove size that is on the glove that was recovered at Bundy?
Extra large.
The glove there is a Brooks Brothers size small.
Right.
They were out of extra large, Your Honor.
Not only that, but the glove in issue is an Aris, and it is not a Brooks Brothers. Can't even tell if it's a man's or woman's glove. Size small. I guess it's Mr. Baily's.
Let me state very clearly, and I should point out that if Miss Clark thinks that hand and this glove would ever work together, her eyesight is as bad as her memory.
Judge Ito's ruling on this issue was a split one. He ruled the defense could not present the glove as a replica of the one found at Simpson's mansion. It was, after all, neither the same size nor the same brand. However, Judge Ito did allow the plastic bag if the defense were to establish that a similar bag was available to Furman in the homicide kit. You saw that he did so in the afternoon session. He held up a Ziploc bag. Mark Furman replied they did not have these zipper lock bags in their kit. However, they did use plastic bags, which were then heat sealed at the jail. We're in the middle of a 5-minute recess. We'll take a short break and be back with more right after this. We're still in the middle of a brief recess in this afternoon session. The morning session was dominated by arguments outside the presence of the jurors, and those arguments became heated when Marcia Clark accused F. Lee Baily of lying to the court.
Clark, let's assume, for the sake of the argument, that what you say is correct, that this misrepresentation has been made to the court. What action or sanction do you seek as a result?
I think that the witness should be precluded from testifying. I think that Mr. Baily should be cited for contempt and fined substantially. As an officer, an officer of the court, he has lied to this court. He is impeached by his own witness.
I ask that you put a stop to it. Either put Cordoba on the stand
Excuse me, Mr.
or
Baily.
stop her from testifying.
Stand up and speak when it's your turn.
Mr. Baily, do not interrupt counsel. I understand this is a volatile issue, but it's a big problem for the court. I'd ask you to control yourself, sir. Ms. Clark.
I think that what has occurred is very serious. And I think that the interview with Mr. Cordoba makes it's very stark. There are no gray areas here. This is not a matter of hair splitting anymore, as Mr. Baily got up to represent to the court this morning. Mr. Cordoba was confronted with the statement that Mr. Baily made, that they spoke. He said, no, we did not, and I would remember. And there was the opportunity to say we had some conversation, and he did not do so.
The jury was finally brought ringside about 2 hours later than expected. Baily proceeded right where he left off Tuesday in his cross-examination of Mark Furman, the prosecution's preparation of the detective as a witness.
Tell us, please, what it was you offered these lawyers in that room about your vocabulary, Detective Furman.
Did
Overruled.
Would you answer?
Yes. That I don't use any type of language to describe people of any race, such as what is alleged by Kathleen Bell.
And you never have. Is that right?
Sustained. That question's irrelevant.
Did you say to the lawyers who were trying to prepare you for the Bell problem that you never used that language?
It wasn't asked, sir.
Withdrawn. I'll be more specific. Did you tell the lawyers in that room that you never used the word nigger?
Overruled.
It was never asked.
I'm asking, do you?
Do I what?
That's vague. Rephrase the question.
Do you use the word nigger in describing people?
Presently?
Yeah.
Overruled.
No, sir.
Have you used that word in the past 10 years?
Not that I recall, no.
You mean if you called someone a nigger, you have forgotten it?
I'm not sure I can answer that question the way you phrased it, sir.
You have difficulty understanding the question. I'll rephrase it.
Yes.
I want you to assume that perhaps at some time, since 1985 or 6, you addressed a member of the African-American race as a nigger. Is it possible that you have forgotten that act on your part?
No, it's not possible.
Are you therefore saying that you have not used that word in the past 10 years, Detective Furman?
Yes, that's what I'm saying.
And you say on your oath that you have not addressed any black person as a nigger or spoken about black people as niggers in the past 10 years, Detective Furman?
That's what I'm saying, sir.
So that anyone who comes to this court and quotes you as using that word in dealing with African Americans would be a liar, would they not, Detective Furman?
Yes, they would.
All of them, correct?
All of them.
In another development, the jury may lose yet another member. A defense source tells CNN that the juror, a male of mixed race, is not linked, or is not liked, rather, by attorneys on either side. The Native American Caucasian apparently acts oddly and does not interact or speak much with the other jurors. This juror, if replaced, would be the fifth to depart the case. Only 7 alternates would then remain, with many more months of trial still ahead. Now, our legal analysts have been following the day's proceedings. Let's check in with them for their thoughts. First in Washington, D.C., Greta Van Susteren, a trial attorney and adjunct professor at the Georgetown Law Center, and here in Los Angeles, Stan Goldman, a professor of law at Loyola Law School. Greta, first to you. We heard both F. Baily and Mark Furman reference the Rosa Lopez testimony. We have to remind ourselves, we've seen the testimony. It was videotaped, but the jurors have no idea who Rosa Lopez is. Do you think they'll be confused?
I don't think they'll be confused at this point because they did hear the opening statement by Johnny Cochran, and if they can remember that, Johnny Cochran explained that there would be some witness out there. I don't think he named the witness, but they will be able to sort of piece it together what indeed the defense claims happened that night.
Stan, I'd like to get your assessment of the cross-examination. Do you think that Baily was off his stride this morning after Judge Ito ruled against him in those 2 instances prior to the jury coming into the room, and then he gained his stride in the afternoon session?
Yes, I would agree. In fact, I would think with the exception of some of that clip that we saw just now, he was subdued. He was not his typical fiery self until he got to that one moment. But I think this afternoon he was back on stride, and I think he scored some of his best points. And I think he may have even shown Detective Furman to be, I don't want to use the word cocky, but I think Detective Furman may have gotten a little overconfident in the tremendous success, in my opinion, he has had as a witness over the last few days. Perhaps he's been reading too many of his own press clippings, describing him as being a super witness. I don't think he was quite as good so far this afternoon.
Greta, how do you think the jury will react to that clip that we showed earlier with the rather highly charged questions to Detective Furman? Now, we've seen and heard reports that the jury has grown dispassionate seeing the photographs of the crime scene. Do you think that listening to this highly charged racial language in the questions will have a similar effect, that the jurors will not pay attention after a point?
Well, I don't know, Jim. I think the jurors are probably listening to the exchange we just heard where F. Baily was asking Mark Furman if he used insulting racial remarks. And I think what the jury is smart enough to do is to wait and see. Will the defense produce witnesses that will make Mark Furman out to be a liar? Or is Mark Furman telling the truth? And I think the jurors are smart enough to wait till all the evidence is in to evaluate and to make a decision.
We're still in a brief recess, and while we wait for court to resume, we'll go now to Atlanta and Lou Waters for a news update.
All right, Jim. Families USA, a healthcare lobbying group, says prices of America's top-selling prescription drugs rose dramatically between 1989.
Thanks, Lou. And let's go into the courtroom. F. Baily is at the lectern discussing a letter written by Mark Furman's attorney, allegedly by the defense seeking funds to help Mark Furman for his legal representation. Let's listen in.
Of racism seeks to have police officers, and I believe it went around the country, contribute to make up the costs that had been incurred and were expected to be incurred. It lists some of the salient victories of the Tortolo firm in representing Furman, and claims that Tortolo and Butler had fronted out-of-pocket costs which have already reached over $100,000. To clear his good name, the costs of experts, investigators, and paralegals continue to mount at a rate we can no longer sustain. Ground one, I believe that any money contributed as a substitute for something that Detective Furman would owe as a legitimate fee or cost of representation, if there were any, is a significant financial advantage to him. Second, he says he's familiar with the letter. I think we're entitled to ask him which portions of the letter he was aware of before they went out. And third, I think we're entitled to inquire whether anything approaching $100,000 in costs had been incurred by September 21, 1994, or whether the United States mails were used for a fraudulent attempt to obtain money by making misrepresentations as to costs which recipients would hardly be in a position to second guess.
You want to explain to the court how it is that this letter relates to any bias, interest, or motive as it pertains to Detective Furman's testimony here today?
Yes, I do, because presumably, if his testimony is accepted or admired by the recipients of this letter, the solicitation is still hanging out there. If he can convince them that he's a good guy and he's telling the truth, and O.J. Simpson's a bad guy, some of this money may come in. But I don't believe in an undertaking of this sort that the result is necessarily essential. It is the purpose of the exercise.
All right. Ms. Clark?
That is tortured logic, to say the least, Your Honor. The witness is here in court to present testimony concerning the work he did in this case. He's not here soliciting funds for anything. Number one, this letter is irrelevant to any issue of bias or detective's credibility. Number two, with respect to how monies have been spent in the mounting of the lawsuits for defamation, is privileged. So counsel's not permitted to get into that. I cannot see any relevance to this letter pertinent to this detective's testimony. I mean, it's just absolutely absent.
Well, the issue, as I understand Mr. Baily's argument, is that there is some potential for financial gain that would impact on motivations to testify or how to testify. Do you want to address that particular?
Not reflected in this letter, there isn't, Your Honor. What this letter reflects is the need to defray costs of legal expenses incurred as a result of lawsuits which were made necessary by the defamatory nature of the false allegations made against Detective Furman. But there's no financial gain involved in that pertains to his testimony. The two are totally disparate. He's testifying here today, and this letter was generated when? Back in September, long before he took this witness stand, in an effort to defray legal costs. His appearance today has no bearing. There's just no connection between his appearance in court and this letter and the money it seeks to get. And we're talking about defraying legal costs that were made necessary by virtue of the actions of the lawyers for the defense in this case. So there is no gain to Detective Furman in that regard. And it has not been shown that there is any, nor that there ever will be. To the extent that the court sees there is a financial interest this witness has in having at least begun work or contemplated lawsuits for defamation against the lawyers in this case, that has already been explored. And that issue is not illuminated in any respect by this letter, other than to indicate that he doesn't really have the money to pay for these lawyers. I do not see how it can have anything to do with Detective Furman's credibility on the witness stand, especially in view of the fact that Detective Furman never read the letter. This is something issued by his lawyer, the work product of his lawyer, as was the decision as to who to sue and for what to sue them for, was the work of his lawyer. I understand the agency theories, Your Honor. I'm not arguing with that. But this letter was not generated at the behest of Detective Furman, and I think that's an important distinction to make.
Well, when you call something, though, the Mark Furman Justice Fund, and it's issued by your attorney, don't you think that any attorney would send a copy of these things out for approval by the client before they're sent out, especially if you're talking about a nationwide fundraising campaign and the amount of money that takes? I mean, just in postage, you're talking a substantial amount of money.
Well, leaving that to one side, Detective Furman has indicated he's aware a letter went out that he did not read, that his lawyer drafted. But, you know, do we really want to do this, Your Honor? Do we really want to spend 2 hours now talking about how Detective Furman's lawyer is saying he needs to defray legal costs incurred as a result of the defamation suits that may be filed at the end of this case, which have not been filed yet? I mean, is that where this case is going? How far afield do we have to go on this witness? I mean, we have gone way out there in the past 10 years. Have you ever used a racial slur? a woman who makes allegations about him 10 years ago, and what other cases he's ever testified in. And I mean, we have really hit the outer limits here, and this is far beyond the outer limits. This is the twilight zone. This letter really has no bearing on this detective's credibility, Your Honor. It's a letter he himself has not drafted. And I understand what the court is saying. He gave permission for it to go out, but the language contained in it, which Mr. Baily is going to want to attribute to him, is not his language. So we're creating an unfair inference that Detective Furman wrote a letter, put language in it, and solicited an amount of money that he did not do. This is the work of his lawyer for the purpose of defraying legal costs. And it is privileged material. Especially because Mr. Baily has now said that he wants to explore exactly how much money was spent and whether $100,000 is a fair representation. I can assure the court that it is, and the paperwork exists, but it's nobody's business. It's privileged.
Is Mr. Tortolo going to appear and claim that privilege? Or is
Yes.
Mr. Furman going to assert that privilege?
Yes. This is not territory that I think is really proper for Mr. Baily to explore with this witness. You know, or any witness for that matter. But I mean, this is privileged material, and that Mr. Baily wants to get into. And the real thrust of his cross-examination on this is whether $100,000 was really drummed up in costs or not. That's a privileged issue. Would the court permit us to go into how much a witness who testifies in this court, who happens to have a lawyer, is paying that lawyer to represent them as a witness in this case?
Yes.
Wait a minute.
Rosa Lopez, we talked about it, remember?
But did we?
Fee arrangements, remember?
But they didn't assert it.
That's true, but I allowed the inquiry, didn't I?
Only after they conferred. That was cleared first. I remember Mr. Darden went over to Carl Jones, went over to Carl Jones and asked him, hey, I'm going to go into the fee arrangements. Carl Jones waived any privilege and said that was fine. He did not assert the privilege, and he could have. He was given every opportunity. The court flagged the issue for him, and he elected not to do so.
As I am doing here.
Is that...
So we want Mr. Turtle down here, Your Honor?
Is that
Well, I don't think that, Ms. Clark, with all due respect, I don't think you're in a position to claim the privilege on Detective Furman's behalf.
No.
So either Detective Furman himself has to claim the privilege or his attorney on his behalf.
I think probably it'd be most appropriate if his attorney did so, Your Honor.
Might I be heard on waiver, Your Honor?
Well, let's hear from Mr. Tortolo if he's available.
While the attorneys argue over a letter seeking donations for a Mark Furman legal fund, we'll take a short break and be back with more right after this.
So far as I know, except for a question prompted by the last phone call, which is very brief.
All right.
During this pause in the proceedings, let's go to our legal analyst here in Los Angeles, Professor Stan Goldman. You are obviously much more familiar with evidence rules than we are. Explain what's going on when Marcia Clark is asserting on behalf of Detective Furman a privilege so that Mark Furman would not be required to reveal the arrangement he has with respect to fees to his attorney.
Well, what we're discussing here is the attorney-client privilege, the fact that all confidential communications between an attorney and a client must remain that way with some rare exceptions. Marcia Clark is not in a position to exercise that privilege on behalf of Detective Furman or his attorney. It's got to be one of the two that exercises it. But even if they did exercise it, we're talking about a letter which was written by the lawyers and sent out to apparently dozens and dozens of people around the country. Hardly a confidential communication. So I'm wondering what all the shouting is about, since I can't believe this would qualify as a confidential communication of the sort that one could exercise a privilege with respect to.
Entering the courtroom is Robert Turtolo, the attorney representing Mark Furman.
To a Daniel Lobato of the Northampton Police Department.
Yes, I am, Your Honor.
All right. The issue has been raised in the cross-examination of your client, Mr. Furman, concerning any potential monetary interest he may have in the outcome of this litigation. And this letter has been proffered to the court as some indicia of monetary interest in the outcome of this litigation. And specifically the issue of the paragraph that indicates that your law firm has been fronting, so to speak, the out-of-pocket expenses that have reached over $100,000, and Mr. Baily has indicated he wishes to cross-examine in that area. And in our discussion, prosecution has raised an objection of relevancy and 352, an undue consumption of time, as to that issue. And I don't recall specifically who it was who also opined that there perhaps is an attorney-client issue regarding the specifics of the representation, the parameters, the costs, and that sort of thing. And there's also a potential of waiver if, in fact, this letter itself was published and constitutes a waiver of that.
Well, number one, I will represent to the court that we have expended, including attorney's fees, in excess of $100,000 as of the date of that letter. That's number one. Number two, I'll represent to the court that Detective Furman, to my knowledge, had never seen the letter. I have never given him the letter. I asked him if we could send out a letter to cover secretarial, expert fees, investigators, and paralegals. If the letter isn't clear, I'll make it very clear. We have made it an arrangement with Mr. Furman that we were not charging him 1 cent. We have not charged him a penny. We do not intend to charge him a penny. And that we were doing it pro bono. And that's what the letter is meant to imply. But we cannot continue, as of September, we could not continue to front and put up all of the costs that we've been putting up in paralegals. Your Honor, we do claim the privilege. I wanted to explain why. I really appreciate Ms. Lewis's help, but I did intend to claim the privilege. But I wanted to explain because I've been in front of the whole world accused of mail fraud, which is outrageous statement. And I will tell the court, as an officer of the court, we have expended over $100,000 as of the day of that letter. And the insinuations and accusations by Mr. Baily are outrageous, and I resent those. But we do claim the privilege.
All right, and you want to explain to me how it is that you feel expenses and expenditures on behalf of a pro bono client fall within the privilege?
The services rendered, whether they're pro bono or they're for a fee, in the description of services are certainly privileged. What we checked into with respect to the outrageous character assassination that the detective has been subjected to in the last 9 months and the work that we've done is definitely privileged. And our preparation in connection with potential defamation suits is privileged.
All right, thank you, sir. Mr. Baily, do you wish to respond to that claim of privilege?
I certainly do, Your Honor. It appears that the letter is in fact fraudulent. I'm now told that it is to cover fees. The plain language, which every lawyer understands as unequivocal, is out-of-pocket costs have exceeded $100,000. Now, we're pro bono, we're covering fees, and we're out of pocket. None of this letter, apparently, is true in total. But as it relates to the witness, this office, if they're acting pro bono on the one hand, nonetheless purport to represent him in a money damages claim for defamation to be brought when this case concludes and not before, based on correspondence we've received on behalf of Detective Furman. I've seen nothing to suggest that the $100,000, whatever it was, if it was, is segregated out as for representing Mr. Furman as a witness. And I contend that this letter says that they're representing him as a witness and, in fact, have won 2 important victories that relate to rulings you made, relating to military records and his LAPD personnel records. We also know, and we don't know of any contingent agreement, that lawsuits are being prepared because counsel says they're being prepared, and the witness, more importantly, says that they're being prepared. Now, how much of this money to be received from the solicitation is applied to the lawsuit, where normally the client pays the costs, even in a contingent fee arrangement, is not specified. but I think it a fair avenue of inquiry. And I think the test is, if the $100,000 comes in, does any of that inure to Mark Furman's benefit? And did he expect it to when the letter went out?
As the
And is
attorneys
it not
continue to
solely
argue over a letter sent out by Mark Furman's attorney seeking donations to a Furman legal fund, we'll take a short break and be back with more right after this.
Yes.
Briefly.
First, and I take it this was a mass mailing. Was it
No,
any?
there were like 425 or something. I don't know how many there were. We got very little money. But I do want to say this. I represented him as a police officer, and under the Constitution of the state of California, a police officer has a right of privacy, and it's a separate right. And he has a right to have a private attorney come into court and defend his rights of privacy, which is what I did before you.
Mr. Torlow, before you launch into that, let me just ask, let me finish the question to you that I was trying to ask.
I guess there's been a lot of those problems in this courtroom, so.
Yeah, it seems that way. Mr. Torlow, the question I have is whether or not any of the funds that were generated or anticipated to be generated by this letter, did any of these go to the direct benefit of Detective Furman?
Absolutely none.
Can you explain to me how that is?
Because it goes to my benefit. I'm the one that's out the legal fees. I'm the one that's out paying my associates and my paralegals and my secretaries. Mr. Furman is not obligated to pay 1 penny, not 1 cent. Therefore, the benefit is to me, who's doing this work, and to my partner, Lori Butler, and to our firm. There's no benefit to Detective Furman. Detective Furman, whatever happens in this case, is not going to owe a penny to us. I'm doing it pro bono.
All right. Any other comment, Mr. Torlow? Is that it?
I claim the privilege, and I'm ready to leave if you... I'm ready to leave with you. In fact, I'll catch the next plane to Hawaii if I could get someone to go with me. No, they'd love it. His comment was, please do, but...
No, I said it was a good idea.
Oh.
I still think so.
Right. I'm sure he does.
All right. Well, today's been a pretty contentious day. All right, any other comment from the parties? Mr. Baily, Ms. Clark? Certainly.
Simon.
I think that eventually,
Sus
I know,
in
Logan's
studios,
defense
Greta,
is
your
to let any
reaction to what you've just
defendant
heard?
off the witness stand. At some point, we have to. And if we get into this letter, this is going to be another. Look at what it just caused now. Just to claim a privilege, just to argue the issue.
Oh, we were lucky Mr. Torlow was in the building.
We were, and we are. But just under 352 alone, the consumption of time to go to an issue that is basically a privilege matter, because the heart of it is a privilege matter, to impeach someone's credibility, it has no impeachment value on Detective Furman. He has no benefit to gain from this letter. His lawyer hopes to be made whole by it because he has expended so much time and effort on his behalf with no recompense. And that's all you have here. So the bias and motive issue, which is what this should be going to, is non-existent. So the letter is really and truly irrelevant, in addition to being privileged.
All right. Mr. Baily, any last comment after Mr. Torlow's comments?
Well, I think I've expressed, Your Honor, the fact that even if nothing more, Mr. Furman is getting a free lawyer, if he is. And to me, that's very cloudy, by virtue of this solicitation, where he would not have gotten a free lawyer, perhaps, if he hadn't authorized the solicitation. That is a financial benefit sufficient to warrant cross-examination.
All right.
But he had a free lawyer long before.
Thank you, counsel. The issue of cross-examination and the extent of cross-examination is something that, thankfully, the appellate courts have rested significant discretion in the hands of the trial court. And in some areas, when we deal with, say, for example, racial bias, the courts have indicated that I must give either side wide latitude in cross-examination on racial bias and those issues, and the court has done that. This is an issue of financial bias, and given the representations of Mr. Tortolo, the financial interest of Detective Furman with regards to this particular letter is remote, and I find it not to be relevant. Were it to be relevant, it would cause an undue consumption of time given the various issues that are here, and the claim of privilege also goes to the heart of the letter. So the prosecution objection will be sustained.
We ask, Your Honor, that the questions and answers posed by Mr. Baily yesterday, in advance of our having been given the opportunity to see this letter, be stricken from the record.
No, he was allowed to cross-examine on whether or not Mr. Furman contemplated legal action against the lawyers in this case. That's fair cross-examination.
Right, no, but he also asked about the letter. That's what I'm asking to be stricken.
I think there's only, if you can show me where that is in the record, I think there's only a question or answer that's pretty innocuous, and we stopped at that point with the purpose of getting the letter to examine it.
All right, may I readdress that with the court after I've found the passage? If that's the case, then there is no point. But
I have to tell you, my recollection of it is that it's so innocuous that I'm not really inclined to stir the pot anymore.
Very well, Your Honor. What I'm concerned about is final argument, though, and addressing an issue that the court has deemed to be irrelevant under 352.
Well, if there's no letter to argue, then I suspect it won't be argued. Given the panoply of issues that are here to argue in final argument, a passing reference in 2 questions and 2 answers, I suspect won't carry the case. If you disagree, look in the record, see what you think. I'm just not inclined to address what I consider to be such a minimal issue at this point. Maybe if I think about it tomorrow morning, maybe I'll think about it differently, but I got to tell you at this point, I'm not real persuaded.
All right, let me look it up and see if it is worth it. I appreciate it.
Okay.
May I learn, Your Honor, whether this is anyway identified for the record?
It should be. The clean copy will be identified as Court's Exhibit next in order 8.
May I be excused, Your Honor?
Yes.
Thank you.
Thank you, sir. Do you have anything else you wish?
3 o'clock, Your Honor. I'd like a chance to, we have information coming in as we speak. I'd like a chance to confer with my colleagues before we decide.
All right.
The only remaining question is, I have a question I can put today. If you want to save that much time, it's about 3 minutes worth.
Not to drag the jury out and then send everybody home. All right, Deputy Magner, let's have the jury. I'll excuse them. And do we have any DNA lingering issues today?
Have you got any?
An afternoon without DNA. How wonderful.
As the jury's being brought in, Greta Van Susteren, what's your reaction to what you've just heard with respect to the fact that the defense cannot go into this letter now?
I think Judge Ito is dead wrong. I think it does show a financial interest. It is absolutely preposterous, from my experience in practicing law, that a lawyer could have $100,000 of expenses in a lawsuit that isn't even filed. I've handled multi-million-dollar lawsuits with not $100,000 in expenses. I think what should happen is there should be an accounting of what that money is. Perhaps $75,000, $150,000 came in, and where did it go? Did it go into Mr. Furman's pocket? And does he not want those who contributed money to know? Who knows? There are a lot of unanswered questions, but the defense ought to be able to go into it to show if there is some bias, if there is some financial interest. The jury ought to know.
We're going to take a short break and be back with more of CNN's coverage of the Simpson trial right after this.
Baily, in one of the angriest exchanges to date between the two. And this time it appeared that Marcia Clark was the surgeon with a scalpel who successfully altered the defense witness list. Jim Hill reports it all started off with allegations of lying by the defense.
As officer of the court, he has lied to this court. He is impeached by his own witness.
I ask that you put a stop to it. Either put Cordoba on the stand
Excuse me, Mr.
or
Baily.
stop her from catching
Stand up and speak when it's your turn.
Before testimony began Wednesday, the court erupted in some of the angriest arguments yet in the O.J. Simpson case. They concerned potential witness Max Cordoba and whether he heard Detective Mark Furman make racist remarks. With the jury out of the room, prosecutor Marcia Clark played the tape of a statement F. Lee Baily made on Tuesday.
And, Your Honor, I have spoken with him on the phone personally, Marine to Marine.
Clark then played a tape of Cordoba, interviewed on NBC's Dateline Tuesday night.
So you haven't talked Marine to Marine to F. Baily?
No.
Mr. Baily, you can see how agitated he is, has been caught in a lie. And you know something, not in this case, you don't get away with that. There's just too many people watching.
I do not appreciate being called a liar in any court, and I will ask at the proper time for correct action to be taken against the offender.
Baily said he did speak briefly to Cordoba as defense investigator Patrick McKenna interviewed him on the phone.
And I said, Max, as a Marine, I'm proud that you have the courage to come forward and say this. I know that it's painful.
After listening to the testy exchange, Judge Lancito ruled Cordoba cannot be mentioned in the trial until the defense begins its side of the case and calls him as a witness. The two sides then turned their attention and their tempers to proposed defense exhibits. Baily wanted to use a glove and a plastic bag to show how Furman could have carried a glove from the crime scene to plant on O.J. Simpson's property. Clark said the glove was not the same size as the extra-large pair recovered as evidence.
Size small. I guess it's Mr. Baily's.
If Miss Clark thinks that hand and this glove would ever work together, her eyesight is as bad as her memory.
Judge Ito ruled the bag can be used as evidence, but not a size small glove.
Good morning, Detective.
Good morning, Your Honor.
In his third day under Baily's cross-examination, Furman continued denying he's ever used a particular racial slur.
So that anyone who comes to this court and quotes you as using that word in dealing with African Americans would be a liar, would they not, Detective Furman?
Yes, they would.
District Attorney Gil Garcetti told reporters Furman was doing well.
He's coming out the way we expected to in terms of him being a very professional officer, doing a very professional and objective job.
Simpson's lawyers charge Furman has been coached in his testimony. Furman admitted in court he's met with prosecutors about 8 times to prepare for the case. One legal analyst said that's unusually high, but the Simpson trial is an unusual case. Jim Hill for CNN, Los Angeles.
In a broadcast interview this morning, defense attorney Alan Dershowitz said that police officers are routinely taught to lie by their departments when they're on the witness stand. Well, this morning, Willie Williams, the Los Angeles police chief, caught wind of Dershowitz's remarks. This afternoon responded in part by saying that he was glad he wasn't driving his car when he heard those comments. Angry Williams said that he, in his career, has never been taught to lie on the witness stand and knows of no other officers who have ever been taught to perjure themselves while they're on the witness stand. On one other note, the scuttlebutt in the courtroom today from the prosecution was that the O.J. Simpson trial could last into October. Greg Lamont, CNN Live, Los Angeles.
We'll bring you more of today's bitter arguments between attorneys and what they might mean at the half hour on The World Today. And for complete